Good morning. I'd like to welcome everyone this morning, Thursday, May 17th, to the Chino Valley Medical Center, 5451 Walnut Avenue, Conference Room, Chino, California. I'm Dr. Zamuto. I'd like to call the meeting to order. Welcome to all of you who are being webcasted to this morning. I'd like to proceed at this point with our esteemed Machiko Chong doing our roll call for us.
Megan Blair. Megan Blair.
Megan Blair is present
Can you
via
please?
teleconference.
Yes. Can you also announce your address and telephone number, please?
Yes. My address is 330 Park Boulevard, San Diego, California, 4th floor, room 443. Phone number is 619-987-2581.
Do you have a different number?
Or is that the number of the library?
Or is that the number at the library?
We have a 619-238-6695.
6615. 6615.
15. Oh, sorry.
Thank you.
Dr. Buhari.
Present.
Dr. Jensen. Dr. Lawley.
Yeah.
Claudia Mercado.
Present.
Cheryl Williams.
Present.
Dr. Zamuto.
Here.
Andrew Marino is absent.
Thank you for establishing our quorum this morning. I would now ask for any public comments that are not on the agenda. And I need to ask Megan Blair, do you have any public members present at your location currently?
No, there's no public members present.
Thank you so much. Seeing then, I would like to move forward to the review and approval of January 18th, 2018 board minutes, please.
Move to accept.
We have a second.
Second.
So Dr. Lally moved and Dr. Mar second.
Dr. Zamuto.
Yes.
Dr. Lawley.
Yes, ma'am.
Dr. Buhari.
Yes.
Megan Blair.
Yes.
Claudia Mercado.
Yes.
Cheryl Williams.
Yes.
Thank you. Our next topic of discussion, item number 4, regulation update, discussion, and possible action. First is initial fee schedule in Title 16 California Code of Regulation, CCR Section 1610.5.
Me?
Well, should I read them all off?
Yeah.
All right, I'll do that. Also, citable offenses, amended Title 16, CCR Section 1659.31. Next will be Disciplinary Guidelines, amended Title 16, CCR Section 1663. And that's it for Section 4.
Okay. So I will introduce you to the reg packages. The initial licensing fee has the proposed language first in your packet. So you see the language, then it has a memo. And if you look at both simultaneously, basically if you read the memo, this is something that we're doing. The board had already passed this in a different form, but the form that it was in was something that we believe would not be implemented at the end of the regulatory period for Breeze, and that was a concern because we really need to move forward with putting our initial licensing online, and the part that is missing and that this would this addresses is the part 2, the licensing pro rata charges, that when you initially get licensed, it's based on a pro rata since it goes with everybody's birthday. So what we eliminated in this is creating a table. If you look at the language, there's the table has like birth month on the left and then the months across, and then the numbers represent what the prorated amount. In the past, and what our current system is, in addition to prorating by birth month, we also have a system of even years and odd years, which you know. That was the part that we did not think would be implementable. And sooner that we get this implemented, the better. So we just sort of kind of cut our losses and said, let's do something that is already implemented in Breeze from other boards. And so this is what the proposal is, to primarily put this in a new section and to have the set fee table that is prorated and to eliminate our even odd months. Now in the past, we did it for workload distribution because our staff was very low, applications for renewals were high. So what they did is that distributed them every other month so that there wasn't a renewal every month. This system will put it to an every month renewal, but this in combination with our audit system that you approved with self-certification, we believe will be manageable. So that is the essence of this proposed change. Any questions? Yes.
Dr. Lally?
So is the intent to lessen work for the staff because people will be doing them themselves? And part of this is necessary so that they don't have to be asking people how much they owe.
Yeah, go ahead.
The reason why we're doing this is because the algorithm for the even, odd is not,
It doesn't work.
Breeze can't do it.
So
Breeze can do this prorated fee if we do no less than 12 months, no more than 24 months.
Okay.
So this is the reason why we decided to.
So I mentioned workload because workload is something we have to keep track of. We don't want to do a change that's drastic like this and suddenly doing renewals on a monthly basis. But in taking that into consideration, we felt that the change would be doable. The advantage of having the online is the second part. For renewals, we have those online, and people have, for the large part, taken advantage of the online payment option. I think that's the most convenient part. For the initial applications, we'll still have a similar process that we have now because many of the documents are primary source, so we'll still have to receive those from the institutions. Those are not going to be able to come online. But where some of the benefit would be is people, licensees, applicants will be putting in their own information. So we hope there won't be any errors in that and it'll be locked in. And when it comes to the prorated payment, when they're sent the bill of how much, that is auto-calculated by Breeze, whereas now it's manually calculated by staff.
Very good, Terry.
Okay?
So before our board today, we have a recommendation for approval of proposed regulatory language for the initial licensing fee schedule. You need a motion?
It requires a special motion.
Special motion.
How does the special motion differ
For
from the regular motion?
our regulatory language, so that you can delegate to the executive officer authority to move this package forward
Okay.
with the process with OAL and DCA. I'm happy to recite it, and somebody can then adopt my motion. Okay.
Is this for Terry alone, or is this for any of the executive?
So Angie, as your executive officer,
Yes.
and her staff would be then working
That's
with
great.
DCA to move the
Right,
package.
so go ahead and give us the proper language to do a special.
So it would be, I move that we approve the proposed text for a 45-day public comment period and delegate to the executive officer the authority to adopt the proposed regulatory changes if there are no adverse comments received during the public comment period, to follow established procedures and processes in doing so, and also delegate to the executive officer the authority to make any technical and non-substantive changes that may be required in completing the rulemaking file.
You have a motion, please?
So moved.
May I have a second?
I'll second the motion.
Any discussion? Seeing no discussion, we'll start the vote.
Dr. Simoto,
Yes.
Dr. Lawley,
Yes, ma'am.
Dr. Bavari,
Yes.
Megan Blair.
Yes.
Patty Mercado,
Yes.
Cheryl Williams.
Yes.
Okay. Yeah, sorry.
Thank you. Since I'm not keeping count today, I need to let you know the count.
I apologize.
No problem. Next, for consideration, Terry, you're going to present a proposed citation and fine regulatory language.
Yes. Okay.
Do I need to state the actual board issue? Or you can do that.
No, you can do it.
I just saw this bold print and I thought,
Yeah.
it looks important.
It looks important, and
All
the
right.
most important person should be
Okay.
highlighting it.
Policy issue, the board needs to update its citation authority to enforce existing statute and regulations and delete ones that are disciplinary in nature. So I thought that this had a fiscal impact on the board. It was very important. So I'd ask Terry to lead us further.
Okay, I'm going to draw your attention to your packet and the materials in the packet because I think it'll be easier to understand. The first one is, I believe, the memo that describes what the changes are in terms of summary. Then there's the proposed language that says 16 CCR 1659.31 citable offenses that has like underlines and crossed out. Then there's a document that has a little border around it, and it has citations added, and then further down, if you flip over, so it's on duplex, it has citations deleted. This document is kind of the summary that I'm going to be using to show you the different types of offenses we're deleting or adding. And then there's the final document is a spreadsheet that shows you what by statutory codes we have or we don't have compared to the medical board. And so on the right side of that, it gives a description of the type of what the statute does. And then you see MBC and OMBC, and there's a yes or a no. And so what we were looking at initially to figure out which codes we wanted to be updating and adding to the citable offenses, we used this as an initial way to look at what we needed. It wasn't exact, but pretty close. Okay, so just to give you an idea of citable offenses, citations, as you recall, are non-enforcement and disciplinary actions. And they are a process that your executive officer has the authority to issue based on, in our code, the authority given to her to look and see, do we have authority to issue a citation? And so if you do, she issues the citation. She would be the one that would hear any kind of an appeal, and she would make the final decision and issue potentially an order of abatement telling them to do something or not do something and a fine. Okay, so that's the significance of the list of citable offenses. If it's not on this list, we don't have authority to issue it. So when we looked at the list, we were a little behind in updating this. There are many statutes that were not listed. And among them, I guess the best way to kind of conceive of this is that sometimes the statutes will make something illegal, but it's not a disciplinary action. It's not a basis that you would consider limiting or putting someone on probation. But they still violated a statute. So what do? So what they created was the citation, is that you could still hold people accountable for when they violate the statute. So the types of cause of action that we're adding would be in that category. So if you look at this one with the border, in conjunction with the comparison, the ones that we're adding, for example, the first one is the 650.1 unearned rebates, refunds, and discounts. And then they have a 0.1 and a 0.7. Those are areas that if people are violating what the statute says about unearned rebates, discounts, refunds, then if they violate that, then that would be the basis for issuing the citation. And we do get a number of complaints about this, so we have not been, up until now, wouldn't be able to issue a citation. Okay, so the next one, you go down 802A, that's a failure to report settlements to the board. We're correcting, we did have a reporting one, but we're correcting it to be A as opposed to B. So that's not so much of a change, it's just an amendment. The 252, unlicensed practice by a physician and surgeon. And this is specific to due to inactive, suspended, revoked, delinquent, or expired license. That's opposed to someone that's never been licensed as a physician and surgeon. They have a different code section in terms of unlicensed activity. So this one would be if you had somebody that was delinquent, inactive, and still practicing, then how would you, the only way the board can hold them accountable is if they would issue a citation. The next one, 225E, failure to comply with an investigation. We often get this problems, non-compliance with when we're investigating, and it tremendously affects our overall outcome and quality of our enforcement. So this is a good tool for enforcement, even though it's not disciplinary in nature again. Unprofessional conduct, H, let's see. Professional conduct, 234. I think I limited this one to
This is the one on the interview if they fail to.
oh yeah, participate in the interview with the investigator. Yeah, it's not really unprofessional conduct because the unprofessional conduct general section is what you use for your basis of your disciplinary actions.
Gary, can I ask, each of these citations we're adding,
Yes,
are they accompanied by a financial fine?
yes, they could be, but it would be on a case-by-case basis.
And who sets the fee?
Angie would, the executive director. And so,
Within the confines of the maximum minimum that are listed here.
so if you look at, if for example you look at the language itself, it has a section A that talks about the amount to be levied by the executive director shall take into consideration factors in the subdivision B3 of 129 and 125.9 to the extent which the person has mitigated or attempted any damage or injury caused by the violation. That's a criteria that the executive director would look at when she's trying to figure out where she should set the fee. And the basic structure is like 1 to 2,500 and 2,500 to 5,000. So the anything under 2,500 as a fee, she'd be looking at any kind of attempt to mitigate, cooperate, things like that, as opposed to not. And then for the more expensive one, the criteria that exists already in statute, it says notwithstanding the fee amounts in subsection A, the citation may include a fine of $25.01 to $5,000 if one or more of the following circumstances apply. Citation involves a violation that has an immediate relationship to health and safety of another person. The cited person has a history of 2 or more prior citations of the same or similar citations. The citation involves multiple violations that demonstrate a willful disregard for the law. And citation involves a violation or violations perpetrated against a senior citizen or a disabled person. That's the official criteria that the executive director would use for the higher amount of the citations. So any of these could fit into both, depending on if they meet the criteria in either A or B. Good question. Let's see, do you want me to keep going down the list for those we're adding to give you an idea of the subjects that we're adding? Or what is your preference?
I think that the list speaks for itself. I think
Okay.
that if no one has any further questions about any specific citation, we can move forward. Yes.
question for the cures registration. Are we giving them a time frame to get that done? I know we're going to get into that later, but it says that we can give them a citation for non-registering.
They should already be registered.
Everybody should be registered.
If you are a prescriber, you have to be registered in CURES. Now we'll go into the detail on when you have to actually run the report. That has not taken place yet, but
Okay.
everybody has to be registered in CURES by now.
And that's
Unless
The
they're
only,
retired.
besides that, the only exception to the fact is if they no longer prescribe scheduled drugs.
No, that's not true. If you have a DEA number, you have to register.
No, I understand, but you only have a DA number if you're prescribing scheduled drugs.
You can have
Yeah, you can have
limitations
a
on
DEA
your
number
DEA.
and not prescribe. So if you do have a DEA number, you have to be registered whether you're prescribing or not.
I understand,
Yeah.
but not every doctor has a DA.
Right, if you do not have a DEA
Right,
number,
that's
you
what
do
I'm
not, okay.
If you don't
yes,
have the number, you don't need to do it.
Correct.
So one other, I just wanted to, if you flip over the sheet about the citations deleted, you should know which ones we're deleting. Most of these, conviction of a crime, substantial relationship, selling medical degrees, unlawful procurement of medical credentials, use of fraudulent records, false statements and affidavits, and prescribing drugs without prior examination, all are violations that you would take disciplinary action for, so they have no business being in a citation. So we're cleaning that up. I don't know why we had it initially, but it would be inappropriate, and so that's why we're deleting them. Not that they're not important, but we already have provisions in our disciplinary guidelines for those, and so they should be reserved for formal discipline, not citations.
I just want to take a moment to welcome Dr. Jensen, who has joined us. Thank you for coming. Let the record reflect that she's currently present. I have a question to my right, Dr. Lally.
So as you look through these, there's one that says 2457.5 unconscious, I guess, fee for service.
Unconscionable,
Unconscionable, yes,
Whatever the word is, I can't say it.
right, unconscionable.
charging too much money.
So, yeah, but who determines that?
That would be,
Is Beverly Hills charges a
No.
lot more than Inland Empire?
yeah. I think it would probably, through the executive director's investigation, would look and make some inquiry about what the market rate would be, and then whether it's excessive. And so the idea, unconscionable is a legal term, and that would, I guess, shock the consciousness of, like, for the amount. And so, like, if you had a primary care visit for just a checkup and you were charged $5,000, that would be an unconscionable fee.
That's not the going fee?
As an example.
This bill was sponsored and carried by OPSC several years ago when we had a doctor who was charging for per level of osteopathic manipulation and was charging like $900 for the upper back and then $900 for the lower back for one manipulative therapy. And so, but there was nothing in law that told us that she couldn't do this. So that's the reason why that bill was created.
Comment from Kathleen Creason.
I actually just had a couple of questions. Terry, you had mentioned 2052 unlicensed practice by a physician and surgeon. It seems odd to me that this would only be a site of mine. That seems like something that's very dramatic. Is there no other legal recourse if you discover that somebody who doesn't have a physician's license?
Yes, because it would be different, because we add, and one of the other ones we would add would be if they violate probation. Like, let's say they're on probation, and then maybe there was a restriction in their practice as a term of the probation, and they violate that. One of the things we're adding is a violation of the term of probation for something that we wouldn't necessarily probably be able to revoke somebody's license for, but they're still not compliant, hold them accountable. There is nothing. Well, there is in terms of non-renewal, but if they're practicing, there isn't, when we discover that they're practicing when they're not supposed to be, then they really are violating the requirement that you can only practice when you're licensed. And so it would be, and then because this is only specific to people that really are licensed or as opposed to ones that aren't. There's a separate statute for that. This is the only way that we would be able to hold them accountable, and it wouldn't be a discipline. So, for purposes of people being worried, oh, I don't want to be disciplined, even though they are doing something very serious, it would be something that they would be probably told to abate as an abatement to stop. That would be the abatement, and then the fine would be determined by the executive director. Does that answer your question?
It does, but it just seems like that's a minor repercussion for a very serious
It is.
issue.
It is, but we didn't even have any recourse, like, without adding this is in the added section. We didn't really have a recourse for it. Now, if the board found somebody was, decided that they wanted to make it a disciplinary action, it's still statutory. But right now, I don't think we have this in this specificity about delinquency and inactiveness, and I don't think we have that in our disciplinary guidelines. So, it would be a question for the board if you thought it was so serious that you didn't want to put it as a cite and fine.
Is that the reason that you wanted to delete prescribing drugs without a prior exam because it's more serious than a citation?
Yes. So the deleted section is all of those are bad, but they're serious enough that they should be moved into the disciplinary, formal discipline. Yes, that it would be subject to your
Then I would
discretion.
support someone practicing without a license should be.
More serious.
That should be moved out of citations.
Okay. Is that what you're suggesting? Kind of the serious, yeah. Okay.
Dr. Mahari?
So all of these things we're adding are already in the Business and Professions Code.
Yes.
We're just adding the ability for the board to now cite and fine.
Yes.
So these come up as complaints from consumers, and each one of these things will be investigated.
Yes.
So the question is, how much extra work is that going to add? There are any number of things. There's stuff about failing to respect sterile procedures during things, and that would have to be reported by someone. I have no idea how, and investigated each individual incident.
Right. Your point is well taken. This is additional workload, but it's also true right now if they're not part of that citable list. If it comes up and we become aware of it, particularly through like a complaint, somebody in a physician and surgeon's office can detail all of this and is willing to go on record and stuff, then we'd have the evidence, but we wouldn't be able to do anything.
Well, I think since there's a financial tag associated with it, that maybe at some point you can balance out the charge, how much they're going to pay you for investigating it, and maybe that's where the discretion of the executive director is that this costs us $200 versus $5,000 to figure it out.
May I add a comment on this? Most of the cases when we do cite and fine, it's something that we find in the process of our normal desk investigations or field investigations. So I don't believe it's going to add extra work to when we do the cite and fine. The only thing that it would really add is just some desk time in terms of us writing up the citation and sending that out. It's primarily the only really workload that will increase. But a lot of times when we find cite and fines, some of them come from outside agencies that discover something that they've gone to, for instance, inspect radiological equipment or something like that. And they find the evidence and they send it to us and they say, oh, we can cite them for this. So that's sometimes things that we find.
And then, so in the course of a normal investigation, if you found that someone did something wrong with 3 patients, is this a per incident fine?
I think it would be per incident because it's per action, per violation. They don't come as a group, so if they did it 3 times, it would be 3 actions, that would be 3 violations, that would be eligible for 3 fines.
There's a lot of discretion also between subject matter experts and the executive officer would review all the circumstances of everything that was submitted and all the evidence uncovered during the investigation.
So for example, in that example where you have 3 patients, one of the things the executive officer could do is to say, well, because there's 3 patients, that's a lot. More than 1, more than 2, more than 3, maybe the fine is higher. and it's not just, it's gonna be one flat fine. Or, the executive officer could say, this is what it is per fine, and then multiply. Now, and that would be the discretion. The example, I guess, the effect of that is, since she's limited by the three criteria for over 2,500, one of the advantages of doing per violations is you would have a higher amount total for the first time, because even though there's three, it's still the first time that person has done this violation, so they may not qualify for the higher fine. So you could do higher individual fines or a large just one fine. That would be a group, but that's all would be
That's the discretion of the executive.
right. And one of the things that I think of these is these are all tools, and as Corey said, you discover these things in cases, and then you can't do anything about it. And I think that there is a deterrent that the board has when they have more tools, a mixture of both disciplinary and citation type tools, that physicians and surgeons know the board's watching, and that because it's really, I always think enforcement is not fair to those that follow the rules, because they work harder, they do everything. The people that don't follow the rules, they can be seen as getting away with things for maybe much less. So the advantage of having the ability to issue cite and fines would be that accountability element that may not exist otherwise. And realistically with discipline, ALJs don't, unless something is very, very serious, they may not see it as seriously as the board does, as you've seen perhaps if you've not adopted some ALJ decisions. And so that's one of the other challenges is we may feel that it's serious, but would we get a decision from a judge saying it's serious, And so that's one of the challenges too, is to be able to have both discipline action available as well as a supplementary cite fine.
Do the people being fined have the ability to contest the fine?
Yes, there's an appeal process, and we have that stated in our letter, and what it does is it gives them the opportunity to have two kinds of appeals: an informal appeal, which would just be heard by the executive officer, or a formal appeal, which would then be heard through with an ALJ, and the AG's office would represent the board on that, and they could have their own attorney to contest it. Obviously, the informal is cheaper. We offer both a teleconference or in-person meeting with the executive director, or they can just submit something in writing, and that's it, and then the executive director decides. The difference in the outcome is that for the informal appeals, once they've appealed, which is either met with Angie in person or by phone or in writing, once she makes that decision, it's final. That's it. With the formal appeal, obviously they could keep appealing it up the line. So it's more expensive, but it maybe has more options. And they're given both, but with time frames. So if they're outside of those time frames, then they don't apply.
Okay. Any other questions?
So
Comments?
can I get more clarification on this unlicensed practice? And Sabina, this is my question to you. If we delete this is this is there under the citations added. It would be 2052 unlicensed practice by physicians and surgeons, and then due to inactive. As a parenthesis.
But if you read the B&P, it doesn't mention inactive. It just says valid, unrevoked, unsuspended certificate. It doesn't include a inactive license.
Okay.
So I'm not sure if, for instance, if we had a doctor who renewed inactive and decided to practice, can we use this section for a cite and fine?
Okay, that's a different question for Sabina. So.
Well, would it then be considered a valid license? Because the words they use in that code section is valid.
Valid. So it would be, yeah. It's a valid license, but the definition of an inactive says no practice privilege.
Right.
So
It's a status. There's a difference between a status and a valid or invalid license.
right.
Any other questions?
Well, I'm waiting for her answer
Oh,
for,
sorry.
for me. Sorry.
There is a fine set out in that statute already, right?
This is one that we're adding, so it's just a violation. So my question to you is, if we took that out because they wanted it to be more serious and used in our disciplinary among the formal discipline, if we just deleted it, it would be, I guess, available because it's still a statute and it's still a violation. It would be available for discipline, but now I'm thinking of our disciplinary guidelines that we're going to talk about next. Would we have to add that? Because that is not added.
Was it not in your DGs to begin with?
I don't think so. So it would be.
Can I get back to you on that if I can look ahead real quick?
Okay. So I'm just trying to, for the board clarification, we can delete it, but the next package that we're dealing with is the new guidelines, which we can amend to add that in and just have it be approved subject to that addition. But that's what I want to know is the
Are
correct.
all of the deleted citations being added to that section?
Well, all of the deleted citations are already included in the disciplinary guidelines. So this would be the exception. That's why I'm asking that specific question. Because we've accounted for, which is why we decided to delete them,
Right,
because we realized, they're already in your disciplinary guidelines. Because if we took an action, it would be approval subject to deleting this from the language, which we can do, and then we could, the next one, add it to that section. So she's going to get back to me. So any other questions about these?
Just a question. Where do we find these? Are they posted on the website and people can reference, like, if I do this, this is going to happen, or are we just going to hit them with a citation when it happens?
Well, our website, we now have the links, live links to the statutes, so you can see on the statute and our regs. And so they could click into this specific number, in our regulations, the 1659.31 is just the list of citations for us. And so people could click into our website and go to the reg section link and then
So
go
we
down.
got it there.
Yeah.
Okay, so there'll be no surprises potentially.
Right.
If
Everybody's
they read our
surprised.
website, no, there would be no surprise.
Hopefully they don't have to.
I think to be honest, I think we're increasing the amount of citations and fines. We're beginning to do that, and I suspect that we'll do it more. Not necessarily on these subjects. A good example might be when we audit the CMEs for self-certification. If we find people are not really completing the CME, that would be, and that is one of the ones that we're adding. If you look just above the deleted, I'm adding the notice to consumers, reg, and then the next one is the required CMEs. If they fail to meet the required, and then I added the self-reporting completion because they were certifying that they completed it, but they, in our audit, find they didn't, and then sanctions for non-compliance. So all of those would be citations. And so I anticipate that we may be doing more. And now, obviously, if we had to list, we could be having more grounds for issuing citations. Okay? But one of the things that this is kind of an invisible process to the board because you're used to just focusing on the disciplinary actions. And these are things that are sort of its own animal, the fact that the powers lie within your executive director. So you don't see necessarily these actions. When they get sent out and all the interactions is not something that goes for a board decision. So it's sort of invisible, but an equally important part of enforcement.
Will the answer to your question require research on everything else? I mean, can we, my question is, can we make recommendations for the approval of this language and put in a caveat for that specific question that legal will get back to you on that when
Okay. Yeah, I think that.
available?
Yeah, I think for this one for sure,
Yeah.
you can, if the board concurs, then it would be approving the language subject to deleting 2052.
And will this require a special?
Yeah, you got it.
Okay, so I will ask Sabrina if there's no objection to read for us the special language for the recommended approval of this section of regulations.
And then you can add in what you would like to say about 2052, depending upon what I
Yes.
come up with, either today or after I get back to the office.
Yes.
Okay. I move that we approve the proposed text for a 45-day public comment period and delegate to the executive officer the authority to adopt the proposed regulatory changes. If there are no adverse comments received during the public comment period, to follow established procedures and processes in doing so, and also delegate to the executive officer the authority to make any technical and non-substantive changes that may be required in completing the rulemaking file.
Then we have to put a note.
Your one potential edit to the proposed
Yes.
language concerning B&P Code Section 2052.
Yes. And we have to specify, we just say legal,
Determine
determine.
whether to stay inside of
Yes,
offenses
and
or
report back to.
correct.
Does everyone understand what we're doing?
So we're gonna put a caveat.
Right, just on that one code section.
To allow her to get the job done and transfer the information, not hold things up.
And that will still make it a final decision by the board.
Yes.
Right, well,
Okay.
Do I hear a motion?
So moved.
Is there a second?
Second.
Dr. Zambrano?
Comments? Yes.
Dr. Lawley? Dr. Bumari?
Yes.
Megan Blair?
Thank you.
Dr. Jensen?
yes.
Claudia Mercado?
Yes.
Cheryl Williams?
Yes.
Okay, thank you so much. Next topic of discussion is section 1663 disciplinary guidelines.
I can barely hear you, doctor. Sorry
I'm sorry?
about that. I can barely hear you.
I'm sorry.
No
Thank you
problem.
for telling me.
Thank you.
Next section is 1663 disciplinary guidelines. Proposed updated disciplinary guidelines and sexual offense regulatory language.
Okay. These guidelines you have seen before, not the exact draft, so I wanted to just give a little preface before we dive into them. The last version of these had the uniform guidelines, the uniform standards for disciplinary, for substance abusing licensees. We stripped out that language because, among other things, there's going to be changes to it, and so it was seen to have a lot of complications and last-minute changes, and I really needed to get these guidelines in place because it affects your enforcement technically. So all of the uniform standards are stripped out of it. It's the existing update. Most of it, if you recall, is an update both from the 96 was the last time, 1996 was the last time we had disciplinary guidelines, and it has changes that you have been using since 2008 or 9 that are incorporated here. So the actual guidelines themselves are not different. They're just minus the uniform standards. So I didn't add new things to these guidelines. I stripped out references to the uniform standards. So what stands alone is, instead of having a big section on uniform standards, you have the diversion committee and abstaining from alcohol and substance abuse for that, related to that. The other thing, and that's for 1663. The other thing I did that is different is, instead of putting the uniform standards into 1663, I actually had created a separate section. And I did the same with the sexual conduct and sexual offenses. Instead of lumping them into 1663, it was much neater, regulatory-wise, drafting-wise, to put a .2. So if you notice on the proposed language, you have the disciplinary guidelines, which essentially incorporates this package that has our logo by reference. And then the sexual contact and offense language is not new. You've approved it, but that language is just going into a .2. And one of the issues that I raised with that is, there was, in our past packets, we did not explain that the board made a choice in its sexual contact and sexual offense language to go over and above what the statute requires, or we were citing that there was a statute that says in addition to sexual conduct, sexual offenses are defined in other statutes, criminal and in the education code. And we were including both as grounds for revocation, automatic revocation, no stay. And so they, among the things that the feedback I got from legal was that we had to make sure that the board really knew that they were doing that and wanted to do that, and they were okay. And so the difference is in there's the sexual contact language, which has a second statute that says if you have at least 3 offenses, then it's automatic revocation. And that is, if you look, I think I put the, in the memo I put your actual statutes if you want to follow. The 729, Business and Profession Code, defines all of the sexual conduct. And the Education Code section, which is, where's the Education Code section? Oh, Education Code section is the first one, 44010. That one, that's involves, even though it's the Ed Code, it has a neat list of sexual offenders and people that have to register as sex offenders and stuff. So it's a better statute to cite for all the ones that we would want to revoke that status. Doesn't mean all sexual offenses, but the ones defined in here that would be registered sex offenders, that's the group that we want to put in the category to revoke. They're defined in the Ed Code. And then the other group in 729, if you look down, they have an A, and then they have a B, and the B has the word sexual exploitation. And then they have kind of definitions, 1, 2, 3. The one starting with 3, 4, and 5, those are the ones that currently are revocable per another statute, which I put in there, 2246. But the ones 1, 2 are not. And this board made a decision that they wanted even one incident, not wait until you had multiple. And so I just have a duty to point that out, that that is what, in fact, what your prior decisions and approvals did cover, and that I'm going to be explicitly explaining that in the reg packet. But that's the essence of the sexual contact and offenses addition. And what that would do is override your disciplinary guidelines in those specific cases where neither you, or as the board, or the judge could do anything but revoke. That's the effect of that. You couldn't stay the revocation. Like all of the orders are revocation, and then there's stay, and then there's probation. In these cases, that would just be automatic revocation.
So are these changes you made, are they editorial or are they substantial?
This is the same language you approved before.
So there's nothing to approve. It's already approved, right?
Well, we have to reapprove it because I took out, it's technically different because I took out the uniform standards. But for purposes, the reason I'm explaining this is that for the record, when I do a regulatory package, I have to have minutes that talk about that you actually talked about the details and made substantive decisions on the way this is. And we never did that. None of the minutes in the past had any discussion, nor did you anybody mention. So one of the ways that I make up for that record is I'm very explicit. So if I'm on the record and everybody says yes, we have some record. So that's why I'm going into more detail for something you've already approved.
Okay.
But you do have to approve it again.
So then, what the recommendation then is to approve the proposed regulatory language
Yes.
that's put forward.
To propose, well, it's the same as you did last time, but it does have, it's in a different section, that's new, and it is, you have to treat it as a new package. But content-wise, it's the same.
Could I have a motion? No? Yes. We have a special motion
Oh,
ahead of us.
I promise this will be the last one.
That's fine. I like special motions. I feel important that way.
All right. I move that we approve the proposed text for a 45-day public comment period and delegate to the executive officer the authority to adopt the proposed regulatory changes if there are no adverse comments received during the public comment period, to follow established procedures and processes in doing so, and also to delegate to the executive officer the authority to make any technical and non-substantive changes that may be required in completing the rulemaking file.
And do we have to add, like, if we change and put that other 52 in there?
On 2052, I just actually looked up, Med Board has that in their regs for a cite and fine, and it was just,
Right. Right.
so I'm not sure
Can it be in both?
if,
Can it
they
be cause for
reference,
disciplinary action and citation?
they reference theirs in their disciplinary guidelines on cease, one of their model languages about ceasing, when you cease to practice, they do reference that code section.
So we could add.
I think it's under model disciplinary language though.
But we don't have that. We don't have that model disciplinary language in the proposed language that they're approving right now. That's what I was.
Right.
So can we make a placeholder in the motion to create that? It's not going to be the exact language though.
Well, no, it was just used to define what practice of medicine and what failure.
Oh, okay.
Right. That's how they reference it for the Med Board.
So if we wanted to do both, as Dr. Parker is asking, could we do both? Like the medical board, would we not want to do both because the board doesn't think it's thinks it's serious enough, and then we have to add a lot of language, or how would we go about it?
I think our first motion, our citable offenses needs to stand as it is, so I can do a little bit more research, and then you can go forward with this motion with the language in front of you for the disciplinary guidelines.
Okay.
Is there a motion?
well, there is, but I have a question.
Well,
Okay.
Why don't we make a motion in a second to discuss it?
Thank you. Motion, please.
Second? So a motion, a second, discussion.
Just so I'm clear, if it's a statutory regulation, we have it as a cite and fine, we can still flip it over and look at it.
Right.
We're just trying to cut down on some of the burden and
Right.
give some discretion to the ED.
Right. She was trying to explain laws have changed. Things have been amended.
Okay.
Laws have been added. So they wanted to capture those in your citable offenses. So that was the bulk of that first edit, was trying to capture new laws or different amendments that weren't in there before. It had been a while since that had been updated.
So if we leave it just as it is, we can always decide that
Absolutely.
we're the guy with the license is going to jail, or whatever it is we decide.
We're not sending anybody to jail.
But because I'm just looking at all the rework and everything that's going to have to be done, whereas we can finalize it today and move it forward, and we would still have the option to take an action.
Right. Your disciplinary guidelines, as they're written, or as you guys potentially may approve, are fine to move that package forward. You'll see a portion of that again with the different uniform language standard. Uniform
Oh, so that would be an
standards language.
opportunity to add the model.
So, right, you're going to see it again anyway.
Thank you.
It's not the last time.
Yeah, but that was a good point, Dr. Lawling, that it's because it's in statute, the board it's a violation that the board could act on.
Any other discussion? Call for the vote, please.
Dr. Zabuka,
Yes.
Dr. Lawley,
Yes, ma'am.
Dr. Kumari,
Yes.
Megan Blair,
Yeah.
Dr. Jensen,
Yes.
Dr. Mercado,
Yes.
Cheryl Williams.
Yes.
Thank you, everyone. Number 5, our next topic. Update, discuss, and possible actions, Senate Bill 798, Healing Arts Boards, Kathleen Creason, Executive Director, Osteopathic Physicians and Surgeons, California. That's the one.
Hello. As you know, and you may recall, the California legislature passed a bill last year as part of the OMBC Sunset Review Bill. As part of that bill, they incorporated a section that requires a minimum of 3-year residency for physician licensure. So they created a new training license for the first 3 years of residency and then authorized full licensure after that point. We have some strong concerns about the implications of that, and we have been in discussions with the Senate Business and Professions staff to try to address some of those. We did submit a letter to Jerry Hill, Senator Jerry Hill, back in December that outlined our specific concerns. And some of them have agreed to be addressed, but there are others that we are still in conversation. As an example, there are, to our understanding, several 2-year residency programs. And we're trying to confirm that, and if so, address how that's handled. There was nothing in the law about how long a physician could have a training license. So, for example, if they had a delay between their intern year and their following residency years, there wasn't anything indicating whether or not they would be able to continue with that training license. We had issues with, we actually recommended that there might be an opportunity to have alternative pathways. So that if somebody doesn't have that 3-year residency program in that exact form, are there other opportunities for them to fulfill the requirements and still be eligible for the full physician licensure? One of the issues is military, as an example, because military physicians don't receive a 3-year residency per se, so they would then not be eligible to become licensed in California. And then we also have the issue of physicians coming from other states. You might have a physician who's practiced for 30 years in another state and done very well, not had any disciplinary actions at all, wants to come to California. If they haven't completed a 3-year residency, then they would not be eligible for licensure in California without going back and then completing the residency. And then finally, we want to see what the impact is on patient access to care. We want to make
Sorry to bother you. You need to speak a little louder.
Sure.
Please,
Outside
thank you.
voice.
Thank you, sir.
Absolutely. So the final point is we want to make sure that there are, we want to assess the impact on patient access. We want to make sure that if physicians are wanting to practice in rural and underserved areas, that there's not a negative implication or an impact from this legislation. So we do continue to work with the Senate Business and Professions staff on these issues, and we are hopeful that we can come to some resolution.
Any questions?
What's the impact that you've seen on patient access so far? Have you done any preliminary studies on how that could be affected?
We have actually asked if an assessment can be done of the potential implication on this. So, for example, can we determine how many physicians currently have not completed a 3-year residency and are practicing, and if so, do they tend to practice more in rural and underserved areas? So this legislation actually doesn't go into effect until 2020. That's another one of our requests. We want to delay it to make sure that we can assess all of the potential impacts.
What's the feedback from the staff? Are they pretty receptive to your message, or are they asking for more data?
They are actually looking for additional data. They are interested in having conversations and trying to come to resolution.
Anything we can do for our meeting?
We didn't support it. We didn't think it was a good idea at all.
And it was a difficult position because it was the renewal of the licensing board, so that it was a difficult position that this board was put in, because you had to support the legislation to renew, the ability of the board to continue its operations. But this was a piece that we didn't like, but it was in a bill that we had to get passed.
Okay, thank you very much. Our next item of attention, number 6, pending legislation, discussion, and possible action. Kathleen, did you have an update for that section as well?
Oh, and thank you, Dr. Zamuto. I actually just wanted to mention that OPSC has established a physician opioid work group. So we have pulled together various organizations, physician organizations such as ourselves, the California Medical Association.
I'm sorry, I wanted to interrupt real quick. I want to make sure we stay on our agenda topics.
This is related to this agenda item.
Well, we're now on pending legislation. Which
So,
bill?
There are actually 17 bills related to opioid
So
abuse.
maybe we can, when we get to those bills, if you can like point them out or something like that, so we can make sure that we're clear which bill we're talking about.
That could, but this is kind of a preliminary to kind of set the stage for the discussion on those bills.
So can you then just give me the bill numbers, and so we can maybe take them as a group?
Okay, well, I don't know off the top of my head what all of them are.
We have 80, 20,
Well, that's in the suspense box.
So AB 1752 would be one of them.
And that's been put in suspense.
1998, AB.
AB
And that's another suspense file.
2174.
Yeah, 2086 as well, 2174.
That's another suspense.
Education 2487. Did you have that one?
Yep.
Okay.
Then 2741,
2741.
2760,
2760. 2783.
24 SB,
SB 1109.
and 641.
SB 641.
Yep, thank you, 641. SB 1240, which I know is dead. And I think that's it.
No,
So,
is it 1426 also?
Yeah, it was, that one was also, the last hearing was canceled by
Yes.
the author.
1448.
14,
not 1448.
But even though it's canceled, I think that's important for the board to still be discussing, and it is agendized.
Great, thank you.
You're welcome. So with regard to all of those opioid-related bills that we just identified, OPSC has established an opioid physician work group to address all of those pieces of language and as well look at the opioid epidemic as a whole, so we can give guidance and recommendations on actions that can be taken to appropriately address the opioid epidemic. So as I was indicating, we have our organization, California Medical Association, and various specialty societies, physician representatives, legislative advocates, and top staff members. So we are actively engaged on this issue because it is something that is just such a dramatically important issue for the public health of Californians.
Can you tell us how important, in terms of like Californians, where we stand in the epidemic spectrum?
Yeah, that's a good question, and I don't have statistics in front of me, but my understanding is that California is actually doing pretty well with the opioid epidemic. We can always do better because it is a huge issue, but compared to some other states, we are certainly doing better. Rates of deaths, to my understanding, are declining in California, opioid-related deaths, in contrast to some other states where they are increasing. But we want to continue that downward trend, obviously.
How do these organizations come together collectively on an agenda? What does that look like?
Well, we have just started meeting, so we actually met to talk about these specific bills to make sure that we all understand the various details and impacts of the bills, and we understand where our different organizations' positions are, so we can work together as a physician community. And so that was the initial step. Moving forward, we're going to be looking more at a global issue to talk about, okay, as physicians, what do we see out there, and what our recommendations are that we can help address this huge epidemic.
Kind of let from within California.
Within California, yeah. Thank you.
Thank you.
Did you want to go through the active bills and?
Yes.
So I did do a legislative summary for each bill. You look at that. So I'm not sure if there are any particular ones that really stood out that the board is willing to either support, send a support letter, do an opposition letter. Our main concern, we just went to, Terry and I went to a meeting a couple of weeks ago with the Assembly consultant on the AB 2138. And it was a denial of application, revocation, or suspension of licensure criminal conviction. This bill would ease the restriction regarding licensure requirements for prior offenders by limiting a board's discretion to deny a new license application or suspend or revoke an existing license to cases where the applicant or licensee was formally convicted of a substantially related crime or subjected to formal discipline by a licensing board. Non-violent offenses older than 5 years would also not be eligible for license denial or suspension. We don't see this as a good bill because there are a lot of cases where, so basically if somebody was convicted of a felony and it's been 5 years, we have to grant them a license. And I think that it should be each board's discretion to decide whether that felony, even though it was 5 years ago, is substantially related to the practice of medicine, or do we trust the guy that's had a conviction 5 years ago for a felony is rehabilitated? We don't even get a chance to review to see if the doctor has been rehabilitated. We just automatically cannot deny a license.
Based on that,
right. And there's a lot of, if you read the whole thing, I think we included a copy of the bill. We can't put a doctor on probation for more than 2 years. And most probationers, if you check with Corey, the first year of their probation is really getting them into the swing of things, like the medical ethics course has to be done, the PACE course has to be done, and so forth. So by the end of the first probation, we're really just getting started. But yet they have the authority to petition for an early termination of a probation after the first year. And then we have to grant them the petition and have a response to them within 90 days, or if the probation is automatically terminated. And as you can see, whenever we have a hearing for a petition for early termination, we do it at a board meeting, so that's time taken. Then we have to have the judge write up the report, and it's just basically impossible to get everything done in 90 days. To set up a hearing, have the hearing, and have a decision in 90 days. So it's very dangerous that these doctors are going to get taken off of probation without due process because the 90-day limit is included in this bill.
Do you have any idea of where this came from?
Chu and Assemblyman Chu and Assemblyman Lowe, I think
And
the
the question
co-authors.
is why?
Yes, the reason why this was written is to bring easier access for people to get back into the workforce. Okay, so there are maybe some professions that's okay, but for health professions, I don't think this is a good bill. It's not a one size fits all kind of thing.
It's not, we're not giving a journeyman a license, we're giving a physician.
Exactly. Right, and for our board, I think when we checked last year, we had 3 application denials. One was for a felony conviction, and he never got licensed, and the other 2 were minor things that happened in another state, and they wanted us to license them, but based on the other state action, we decided not to give them a license. So we had 3 doctors out of 1,000 applications that did not get a license. So would this bill really help? Because there was only 3 that was denied.
Do you know what the count was for the MD board?
I do not know.
All of the counts were low.
They're very low.
I think with the medical, well, they weren't at the meeting, but the ones that had hundreds of thousands of licensees, they were 50. They would have 50 of this category.
Right. I think
So
one of the boards,
certainly
out of 3,000 applications, they said they had 5 5 denials, of which they went to petition or a hearing, and 4 of them got a license, 1 did not, and that was a sexual offense. So, I mean, I don't know that this bill is going to help anybody for health boards, and I think that we should submit an opposition.
Other boards, we were originally thinking, well, maybe an amendment to just exempt the healthcare boards, but then we heard like from pest control, they go into people's houses, and where they just said, you know, there was a wide range, even beyond healthcare, where, you know, honesty and trust was a major issue still, even though it wasn't healthcare. So that, you know, the general opposition with all the boards, regardless of whether it was healthcare, was this was a bad bill because it restricted public safety. And the claim that the authors had is that they were not trying to affect public safety, but the reality is you cannot take away the board's enforcement discretion and not have an impact on public safety when specifically it is addressing convictions, not practice, just convictions.
Is
So,
there a motion that we should take a position of opposition?
I would make that motion.
Is there a second to that?
Seconded.
Discussion.
So just to be clear, this bill pertains to all licensees under DCA,
Yes.
yes.
so including the new cannabis, Bureau of Cannabis Control, any new licensees under that Bureau.
Yeah.
So I think what this potentially could be addressed, and there's a big talk about equity and people having a chance to enter the market. So yeah, not all professions are the same, so I can see how this could, you know, keep some people out of the industry that potentially got convicted for something in the past.
The marijuana issue.
Right, but that shouldn't be the case for putting other members of the public in danger.
Well, I don't remember, but like small, I will say small, minor types of misdemeanor convictions and stuff aren't, you know, affected by this.
Just felonies.
Felonies, right.
Well, the way, at one point in California, if you had X amount of marijuana on you, it was a felony conviction.
Yeah, and I can't speak to the penal code now, but
Yeah.
And I know they're trying to change that, and they've actually talked about some sort of forgiveness. Or
Didn't the last initiative change that?
Why? I don't know.
Our lawyer,
Sorry.
our expert.
There's a federal.
And then also, did you guys, have you guys looked at the Hulu report? Are you familiar with the Hulu report? I think, put together by the state. We got a letter once inviting us to,
What is it?
maybe Angie, you can tell us, because it's ringing a bell. The Hulu report was done by.
Yes, and that was the first kind of cornerstone about employment.
Right, so just saying that California is the state that I think we license the most people. So in order for you to make a living in California, you need to have some kind of license.
close to 30 or 40%.
Right, so.
But the data, what ended up happening when the boards really looked at this, is the data didn't support it. That the little Hoover report did a general look, and I don't know, they must have had some data, but it made it seem like there were huge numbers that were denied. And if you got rid of that ability to deny, then there'd be huge numbers employable. But our board has like 1 or 2 a year. So that's not going to make or break employment. And that was true in the licensing board. So I think the idea of this bill was to target, quite frankly, was to target the licensing boards and bureaus, but not necessarily the greater marketplace in California, which is where probably the biggest number of people that this would make a difference. For example, among the things talked about is that we'd have to change on is on any application form, or just some, if they took out the box, did you have a prior criminal background? Okay, if you took out that box, then we would have no way to know about that prior criminal background, and we wouldn't be able to get all the information to make decisions. Well, on other non-licensing type entities, maybe that is a real barrier, and they shouldn't necessarily know that. But this bill is only targeting the licensing agencies who don't really have the numbers of denials to warrant this kind of restrictive measure. So that's the concerns. But I know what you're saying in terms of what I've read about that issue.
And also, just out of curiosity, does he chair any committees? Do you know that?
Low is
Assembly,
the assembly
chair
chair.
of the assembly.
Right.
But
That's
he's the
the
co-author of this.
Yes, okay, that makes sense.
So I
So
said,
I just, yeah,
no, I was just gonna say, in our discussion and whatever we're citing for our opposition would be that this is restricting public safety.
Yeah.
That we do not have, it does not apply to a substantial number of physicians for us, that this would actually truly impact the medical physician workforce in California. Or there's the numbers, the data doesn't support it, like you were saying, there's a very low effect, and that this is also convictions and felonies, not small offenses, which we feel are frequently, related to whether or not someone should be practicing.
And I want to point out too the time frames that you mentioned about that are in this about for a board to issue a decision is also you have to think about all the other entities involved in that, right? The AG's office. It's going to be very, very difficult with that increased workload and those lessened time frames for all of the boards. To try to process all those petitions and get those decisions done in that time frame.
That 90 days is an unreasonably fast response.
And to add on Elizabeth, to your comments, one of the things that was a byproduct that came out is they were saying felonies and violent. And so felonies that were not violent, they would be, we wouldn't have such public safety concerns. But there was an issue raised that sexual offenses may not be considered in that violent category. And dishonesty, any acts of dishonesty that could still have public risks would be kind of glossed over. And that was an issue that they felt that in making the distinction on the bill as trying to protect public safety by just siding with the violent ones didn't necessarily take into consideration the dishonesty ones that could still also affect safety.
Said non-violent, that doesn't.
Medicare fraud abuse.
Yes, yes.
Okay, we've had some good discussion. I'd like to move forward with the vote.
Dr. Zuda,
Yes.
Dr. Lally, Dr. Buhari,
Yes.
Megan Blair,
Megan, are you there?
Dr. Jensen,
yes.
Patty Mercado,
Yes.
Cheryl Williams.
Yes.
Megan, are you there?
I don't see the lights on.
Traction. Is it still on?
Is it still on?
I don't know.
Yeah.
And who's actually writing the letter? Is it coming from,
We'll write the letter.
does legal have to look at the letter?
She doesn't have to.
Daniel.
But I usually send her everything.
All right, next bill of concern.
Did you get everybody's votes?
I have 6 out of.
Oh, I just know. You've got all the way around the table. Can we confirm whether Megan's site is still open?
You have a number to call? Megan? Looking for you.
Hi, I'm from that. You've got the 8.5 month committee.
Oh, we kind of assumed that, but we didn't want to assume, So what we did is,
She doesn't hear for the discussion.
were you here for the discussion of opposition to Assembly Bill 2138?
Most of it, yeah.
Okay,
Sorry.
we can let you. Yeah, that's fine, no problem. You have enough. Okay, next bill of concern?
Okay, so what we did was we included the copies of the bills from this list that the medical board has opposed or had suggested opposition. So I do believe the next one was the AB 505.
505.
It's the very first.
Yeah, it's the very first one.
And what was the gist of the bill that brought up opposition?
They did a nice job on some.
I'll go ahead and I'll read it. AB 505, Caballero, physician and surgeon probation, status in Senate hearing postponed by the Committee on Business Professions and Economic Development. This bill would prevent the board from entering into stipulated settlement for a disciplinary action with the physician if the underlying accusations of the compelling allege a felony conviction resulting in harm to patient safety, drug or alcohol abuse directly resulting in harm to patient safety, or sexual acts or sexual exploitation.
For the most part, I think that we've always went to hearing on a case like this. This is very egregious cases. However, it takes away the board's right to decide whether we want to stipulate into a settlement or not. So it will increase cost for enforcement because every case that involves any of these allegations will have to go to hearing rather than to try to stipulate to a settlement.
Because this doesn't take away the criminal aspect of it. The other enforcement is still in place.
Right.
We're just talking about sanctioning the license.
Right, that's correct.
They're essentially saying you can't sanction the license for any of these.
We can't.
Can't make it a
We cannot stipulate. The ones that Corey sends out for your vote. Those are the stipulated settlements, but we have to actually have a hearing in front of
For all of them.
Right.
So the cost of both the board and the potential licensee is going to be huge in terms of lawyer fees and stuff, guaranteed.
Now you have to be able to determine whether it has merit or not. You have to be able to weigh in on it in some way, shape, or form. Determine, are there any extenuating circumstances or something unusual about this?
Right, because some of our licensees enter into stipulations when they're basically, you got me, I did everything, let's just enter into the stipulation, put me on probation, I'll agree to it. We don't go through the extra time and money through the AG's office, and everybody kind of gets on that way quicker.
I always have a concern when you give up your rights to do things, especially if it becomes legislative in nature.
Yeah.
So just by its very concept, I'm not opposed person, but we as a board have to determine what we think. So I guess
Mr. President, may I make a motion?
I need a motion.
Oppose.
Is there a second? Is there a second?
A second.
Discussion? None being, let's make a vote.
Dr. Segundo,
Yes.
Dr. Lally, Dr. Bukhari,
Yes.
Megan Blair,
Yay.
Dr. Jensen,
Yes.
Claudia Mercado,
Yes.
Cheryl Williams.
That's it. Thank you. Next bill of concern?
The other one was AB 1998, but I do believe that is in the suspense file at this point.
Does that mean we can draw a line there?
Well, just a quick discussion on that. This was the bill that originally started where it said that a physician can no longer write controlled substances for more than a 3-day supply.
Oh.
And then that got kind of gutted out, and then it became a bill that said any physician who prescribes controlled substances must have a safe prescribing protocol in place in the office and must follow that protocol every time you write a prescription. So, yeah, that was another, and I think that Dr. Buhari weighed in on this some time ago and felt that there was a lot of restrictions imposed on physicians. But right now it is in a appropriation suspension file, I do believe.
Yeah, as of May 9th.
But the policy would be good to hear from the board if the board shares Dr. Buhari's concern. And so when we know if this bill comes up, because they do come up and it's not dead necessarily, what would the board think about this? Are you inclined to oppose it, support it, or what?
So the protocol would not adhere to every patient. Every patient is different, correct?
Yes.
So how do you make?
Well, there are sort of templated processes out from national organizations on how to do this. The problem is, what will happen is what I do now. I don't prescribe any narcotics in my practice whatsoever. Zero. I'm out of it because I can't keep up with this kind of stuff. We run a busy practice, And if one of the patients says, hey, can you give me something because I don't have my appointment until 2 weeks, whatever, and I prescribe 5 days or 10 days worth of something, and I didn't comply with all of these safe practices, I can be cited, and it's quite a bit. I mean, this is something that's written by pain management doctors who do this all the time. So what will happen is you'll have very few doctors who will want to engage in prescribing pain medications, opioid pain medications. And then there's
access.
Absolutely, that's what will happen. Because right now it's very difficult to get my patients into pain medication in the pain management centers. So that was my concern with the way that they had written this language. I mean, failure to comply with that is unprofessional conduct, which is punishable by board actions.
Is there anyone who's in favor of this? Okay. Can we take a vote to oppose? We need a motion. Do we have a motion?
Please, motion to oppose.
We have a second?
Second.
No more discussion. No more discussion. Let's take a vote.
Dr. Zamudo,
Yes to oppose.
Dr. Lally,
Yes, ma'am.
Dr. Buhari,
Yes.
Megan Blair,
Yeah.
Dr. Jensen,
Yes.
Cheryl Williams,
Yes.
Claudia Mercado.
Yes.
Thank you. Next bill of concern?
Next one. Is the 2138 that we discussed earlier. So let's see that one. The other one was the 2487. Opiate dependent treatment and management.
Can we read that one? AB 2487, McCarthy, physician and surgeons, education, opioid dependent patient, treatment management, status and assembly on third reading file. This bill will require a physician and surgeon to complete the continuing education course on opioid dependent patient treatment and management as specified within 6 months of first receiving or next renewing a federal Drug Enforcement Administration registration to dispense narcotic drugs for patient treatment, unless the physician and surgeon meets the requirements of a qualified physician within the Federal Comprehensive Addiction Recovery Act of 2016. Anybody know what that is? The Federal Compulsory Addiction Recovery Act of 2016.
It's a federal statute.
Speak up.
It's a federal statute that puts certain requirements around opioid prescribing.
Was CMA opposed?
Medical board did oppose this. I think basically what it's requiring the doctors to have to take a course before.
In 2 years.
Right. It's adding more CME requirements to physicians.
Can I ask?
I think it's been recently amended to change it to roll the requirement into the one-time pain and end-of-life care. The 12 hours, that's a one-time requirement. So I believe that this bill has been modified.
If that's true, that would be I think that would be very reasonable when you first get your license to have the 10 hours or 12-hour requirement for CME or pain and end of life, to have there be your first time DEA or license, however it ends up going, for opiate dependent patient treatment, but not every time you're renewing your DEA every 2 years. Right? That's not reasonable. A one time is very reasonable. So within 6 months.
Just to be clear, in my mind, I read this as when you're prescribing a medication to a known opioid dependent patient, that you know what you're doing as part of this course, as opposed to the general public who's opioid naive, who could potentially become dependent.
I would agree with you. It is for a special set of patients.
But it is a recommendation, it is a requirement for all physicians.
Right.
Because every 2 years, if you were that involved in the opioid dependent patient population, I would think that those patients should be seeking out pain management and other things. You should generally, as a family physician, primary care, not be the one, and none of us usually want to be the one in charge of managing all of their opioids. So I think that's the reasonable part of pulling that out of the requirement every 2 years, is that we are not primarily managing their opioid treatment. They should be seeing instead pain management.
Well, the current guidelines specify that if you are changing even their dosing, that they need to see a pain specialist in consultation before you do that.
So we are not making those decisions, so we're primarily responsible for them, so I don't think we should be held to the same education.
So we need a vote to oppose.
Move to oppose.
Second. Any more discussion?
Who's my second?
Second.
Seeing none, let's take a vote, please.
Dr. Zamora,
Yes to oppose.
Dr. Lally,
Yes, ma'am.
Dr. Buhari,
Yes.
Megan Blair.
Yeah.
Dr. Jensen,
Yes.
Cheryl Williams, Patty Mercado.
I abstain.
Can you abstain?
I just,
You can do whatever you want.
Do whatever you want.
that's
It's a free country.
exactly me.
Any other bills?
2741. This was their stand on this was to oppose unless amended, and I'm sorry, I don't know what amendments they were looking for in this particular one. But this bill would prohibit a prescriber as defined from prescribing more than a 5-day supply of opiate medication to a minor unless the prescription is for specific use. This bill would also require a prescriber to take certain steps before prescribing a minor a course of treatment with opioid medication, including discussion of opioid risks and obtaining specific written consent except in specific instances.
CMA's position.
The medical board was opposed unless amended. And
But we don't know what the amendment is.
I apologize. I do not know what their amendment.
Kathleen, do you happen to know what the amendments are?
As I recall, it was an issue with the limitation.
How many days?
On the 5 days, the 5 days.
Yeah, that policy-wise, that's the issue that it would be helpful to hear from the board about, is that there were 2 bills. One had 3 days limitation supply, one had 5 days. Is what do you think about that tool of limiting opioid addiction through limiting supply? What's the consequence of it?
It was for minors too, right?
Yeah.
Just for minors.
So in essence, minors usually don't require as much pain medication as adults. They don't have agendas. They're really wanting to get on with their whole lives. So you can really take care of most kids with just some Tylenol and such. Where I think this impacts people is, because I work as a hospitalist, we will get kids in here that have fractured femurs. And they're waiting to either have a reduction or they've had their reduction. So they're going to leave with more than 5 days because, a broken bone is a broken bone. Now, the advantage we may have, whether it was intentional or not, is that we've always put a reason for our medications and our lab tests. We just have, because it's what you should do. We have run into, though, where just recently we wrote for a kid that had a bone cancer, sarcoma, osteosarcoma of his humerus. Anyway, it was an uncontrolled pain. So the consultant came inside. He wrote for like a week till you could see him again. They weren't going to fill him. He actually had to drive over to the pharmacist and ask the guy what was going on. And the guy had thought that all this had already been passed. But it's just what it's out there. But I don't think you're in a position to tell doctors how long they should give anything.
Well, the other proviso to this is the fact that cancer pain is outside.
Well, it is. It's supposed to be outside this. I agree with you.
Now, it's in the bill that for these reasons, management of pain associated with cancer,
And
use of palliative or hospice care, management of chronic pain not associated with cancer, and treatment of substance abuse disorder. So those are the exceptions that you can't prescribe for more than a 5-day supply.
I think the only exception that Dr. Lawley even cited was acute trauma. There are some exceptions which legitimately you would think will require longer than 5 days of treatment, which aren't listed in here.
Right.
So do we want to,
Again, they're taking away the
should they be
discretion of the
listing
physician.
I
everything
think we
that
should
could
allow
possibly
us to
happen?
practice a little bit. I mean, you did give us a license. You should have a little discretion.
I mean, I'm opposed to any legislation that dictates how you prescribe.
Just length of time.
There are concerns I understand when a child goes and gets his wisdom teeth pulled from the orthodontist or whoever, the dentist, and he gives him a 30-day supply of an opioid. That's a problem.
No, that is a problem.
But that's education. I don't think that's
Parents are
legislative.
So I would move to oppose this only on the issue of the length, the day issue. I don't know what it's called. Length
The duration. That's the supply.
I'm okay with the theory. I mean, we should be very discretionary in giving kids anything. But I think you should tell us 3 days, 5 days, or 10.
So you're saying opposed with the amendment?
And I'm pretty sure that's what the board wanted.
All right.
The time frame.
So why don't I suggest that we oppose with
Unless amended.
oppose unless amendment, find out so we're all on the same page about what all those amendments are. Fair enough?
That's fair.
Call for the vote?
Second.
Dr. Zamuro,
Yes.
Dr. Lawley,
Yes.
Dr. Bukhari.
Yes.
Yep. Okay.
Speak up if there's something you can give us.
Is there something you want to say?
On the bill.
Yeah. You okay?
Dr. Bukhari,
Yes.
Megan Blair.
Yeah.
Dr. Jensen,
Yes.
Claudia.
Yes, and I'll add something.
Cheryl Williams.
I guess the one thing that comes to mind is accessibility, like we heard earlier, like if a parent, can't take a day off of work to go get the child medication because they're skilled labor, they can't miss an hour of work, or they get off of work late and the pharmacy's closed and the child's suffering.
Yeah, you will.
How can we
You'll undoubtedly run out of medications before your next visit if it's 5 days.
Yes.
It just
Always
will
works.
happen.
Yeah.
And we're putting it on the parent to find the time and resources to make that happen.
Yes.
That's gonna happen.
Okay, next bill?
Next bill, SB 1426.
Authority to prescribe dispense dangerous drugs and devices. 1426. 1426, Stone Pharmacists. Authority, this is giving pharmacists the authority to prescribe and dispense dangerous drugs and devices. Status, Senate, first hearing canceled at the request of the author.
So it is dead.
Exactly.
It's dead.
It's dead?
For now.
For now.
Yeah.
Do we need to discuss it if it's dead?
Probably not. It'll probably come back looking a little different. It doesn't.
All right.
Yeah.
Well, but I would pause a moment because policy-wise, it's good to hear what the board thinks about
All right,
an
let me
issue.
read it.
And then if later it comes that we know what the next thing.
All right, so we're gonna have to vote.
We'd have to discuss it again anyway.
Requires pharmacy board to convene a public health and pharmacy formulary advisory committee to advise the board in promulgation regulation to establish a formulary of drugs and devices that an advanced practice pharmacist may furnish to a patient. The bill would require the board to establish a formulary of dangerous drugs, aren't they all dangerous? And devices, they're all dangerous, that an advanced pharmacist may furnish to to a patient and would authorize an advanced pharmacist to furnish a dangerous drug or dangerous device included in the formulary to a patient pursuant to a diagnosis by a healthcare provider practitioner. So why wouldn't the healthcare practitioner prescribe the dangerous drug or the dangerous device? Why does the pharmacist need to prescribe anything?
The scope change.
Pardon me?
It's a scope change, Bill.
Scope of change. Scope of
Skill to change
Yeah.
the scope of a pharmacist.
This is the first time I've ever heard of anything like
So-
scope of change.
I read
Scope of
that
change
there
is
was
not with a name.
I read that in Florida there was a big bust of pharmacists that were doing special formula or what they call compound. Now, is this the same thing as compound?
No,
No.
no.
Okay, so how what's
It's a different subject.
Doesn't this mean the new, I was gonna say, where you can call in to these pharmacists or to a doctor and you speak to them and they can
No, that's
diagnose.
different.
But it's
That's
centralized.
No,
No?
no. This is only for a pharmacist.
So we can walk into a pharmacy and then say.
I got a cold.
Yeah.
Okay, I'm going to give you amoxicillin.
No, that's not.
and
I would say from my practice as a hospitalist, like Dr. Lally, I work well with the pharmacists, I respect their opinions, but they do not see the full scope of the patient, and that is my issue with that, is that we have a pleasant, educated discussion sometimes on, no, the reason, although that is another drug on formulary, that is not a possibility for this patient is because you don't know they had this awful reaction in the hospital to this, or they, are actually on this other medication, which is prescribed at a different pharmacy, which is why you don't have it on yours to, cross-check.
Or they did not examine the patient and find out that
And
they
they
had
didn't
hepatomegaly.
Actually see the
and
patient,
cirrhosis.
and they aren't actually trained as a physician to diagnose them. So,
we're also concerned, so there's going to be an advisory committee. Who are these people in this committee?
Ah.
Like, what are the qualifications? Like, Bureau of Cannabis Control has a committee, and there was like a couple hundred applications, and if you were selected, then when you look at their list, you're like, well, can you tell me, like, why they qualified? Like, where did they go to school? Do they have a science background and they're advising in manufacturing? Are they a scientist? Are they a chemist? Or are they just a business owner running a cannabis
It's
business?
a dangerous
So
precedent.
for this, I see Walgreens and CVS already over this. Like, how can a big corporation dictate what patients should be taking without a...
it's public safety.
Yeah.
It's like public safety.
Because they're going to own they own the insurance company who pays for it too.
The committee, it says the committee shall consist of the following members: 2 physicians and surgeons licensed to practice medicine, 2 advanced practice registered nurses as defined in section 2725.5, who have prescribing authority and who are licensed by the Board of Registered Nursing, 3 pharmacists licensed by the board, at least one of whom is employed as a community pharmacist and one who is employed as a health system pharmacist. And the Medical Board of California, the Board of Registered Nursing, and the board may each submit to the governor a list of up to 3 names of individuals to be considered for membership for each of the vacancies required to fill the licensing of each of the boards.
Still dangerous.
Out of the board.
It doesn't, that doesn't evaluate each individual patient and their individual conditions there. No.
No, we're just discussing.
Oh, we're just discussing.
Since there's no action at this time, it was important to have this discussion.
Yes,
Because at this
That's
point
right.
in
Sorry,
time,
I lost track.
thank you.
there's no one who's supporting this concept.
It's good for staff to hear what you're saying in your real life examples, so we understand when these ideas come back up again, that's not a good idea.
Okay, next bill.
That was it.
That was
Those
it.
are the ones for the
What about the
concern.
probation?
SB 1448 is, again, this was the one that was actually in the sunset bill where Senator Hill wanted the probationers to report to all their patients that they're on probation. And that, at that time, that bill died, so he's resurrected it in SB 1448.
Yes.
And it will require the medical board, the podiatric medical board, the osteopathic medical board, the naturopathic medicine committee, and the chiropractic board and the acupuncture board to require their licensee to provide a separate disclosure to a patient or patient's guardian or healthcare surrogate before the patient's first visit if the licensee is on probation pursuant to a probationary order made on or after July 1st of 2019, The bill would also require those regulatory boards to provide specific information related to licensing operation on the regulatory entities on license information internet website, which we already
Ready
do.
to do that.
We already do that.
And they Google you before they come. So
Right. Right. But they're calling this the what the Transparency Act or something separate. Right. So what he had a meeting, and when we went to that, he had speakers, and they were majority of the speakers were the young gymnasts who did not know that their Dr. Larry Nasser. But that doesn't even fit this because Larry Nasser was never on probation. He was never, nobody even knew that there was no action ever taken against him. He wasn't even under investigation. Right? So this Transparency Act isn't going to eliminate something like that.
Yeah, nobody's going to see him now while he's in jail.
Right, right.
The Felony Act before, we're talking about.
Right, that's true.
Yes.
So I think the last time we talked about this, we said that I think the board decided that some probations should be reported to their patients, but not necessarily every probation.
We said egregious act.
we said
Right.
egregious
Right.
sexual
Sexual
misconduct.
misconduct, gross negligence, that type of thing. But this one doesn't make any
Distinction.
distinction as to it's all probation. So this week it's been re-referred to the Committee on Appropriations, so it is still alive. I do believe I think it's going to hearing on May the 24th, if I remember correctly. This one, isn't it?
CMA's position.
I do believe they took no stance on this
No
one.
stance.
CMA is opposed.
They're opposed.
CMA is opposed. Medical board
Didn't take a stand.
did not take a
Oh.
stand.
You can always decide to watch.
Right.
It's going to hearing. I think the first hearing is on the 24th. So after that, we could see what happened at the hearing and decide at that time.
All right, that's why you're saying just watch right now.
Should we watch? Okay.
All right, so no actions required.
It's scheduled for hearing on the 22nd.
22nd. Thank you.
So put that on the agenda for us to for our next meeting. Anything from legal? Thank you, Sabrina.
I wanted to go over AB 710.
AB 710. Can I suggest, since our next topic is the whole cannabinoid by Sarah Gardner, attorney, maybe we'll let her do her part and talk about it? Because then we'll be better informed. Okay, so put a little star by there to bring it up there after talk. Okay. It's my sincere pleasure to thank Sarah Gardner for being here today. It says attorney 3. What is attorney 3 called?
That's just the title. I'm a senior attorney for Vera.
A senior. Well, we're pleased to have you with us today,
Thank you.
leading us on the discussion of cannabinoid control. And are there slides with yours?
Yes.
All right. Just a quick second.
What do you want to do?
We need a biologic break.
I was about to suggest that.
Why don't we take a biologic break and then we'll come back
Thank you.
with the cannabinoids.
Out the door too.
I'll put this on hold. Stop.
There's another one.
Now that we're back to a serious topic, I'd like to reintroduce our guest speaker today on cannabis law and regulation, Bureau of Cannabis Control, California, Sarah Gardner, Attorney 3.
Yes.
Please proceed.
Thank you for having me. As we go through the slides, the second slide we have in the packet is just a map of the country, and in green are all the states now that have adult use cannabis. You also have the medical states, a lot of limited use states where they're allowing the CBD oil, and then just a very small handful of states where it's all completely illegal. So
And then this map is not showing, so like there's states that have both.
yeah, no,
This is just like a generic.
yeah, it's just a generic graphic to get an idea of where some of them are. Generally, if they have adult use medicinals already allowed. So, cannabis use for medical purposes has been legal in California since 1996 when the Compassionate Use Act was passed. But it wasn't until October of 2015 that the legislature passed an actual act to control and regulate cannabis. So that was the Medical Cannabis Regulation and Safety Act, which was passed in 2015. And then in November of 2016, the voters approved Prop 64, which was for adult use cannabis. In July of 2017, the trailer bill, which was signed by the governor, merged the two systems into one. So we now have the Medicinal Adult Use Cannabis Regulation and Safety Act, which is a bit of a mouthful. So once with the passage of the trailer bill, we very quickly drafted a set of emergency regulations that were approved in December of 2017, and we started issuing licenses about mid-December with an effective date of January 1st. So beginning in January, those licenses became effective. We've been continuing to issue them, and we are just about to go into readoption, and then very quickly after we will propose our final packet, which would be finished sometime before December 7th. So some big highlights of what we have now in the MCRSA, which is what we call it. Local control is a big aspect of it. If the local jurisdictions have banned an activity, we cannot issue a license for that activity. Vertical integration is allowed. That was something that was not allowed under the MCRSA, but it is allowed now. And what that means is you can have cultivation, manufacturing, dispensing all under one business. The exception for that is laboratory testing, which has to be independent and cannot have an interest in any other license. And the other interesting thing about this is we have 3 state licensing authorities, so it's not just the Bureau, we also have 2 other state licensing authorities. If you go to your next page, some more key highlights of the MCRSA. It's a single regulatory system for commercial cannabis activity. It requires all persons engaged in the commercial cannabis activity to be licensed. It said it does allow local jurisdictions to control what activities are permitted, and it places the protection of the public as the highest priority. Now, next slide, commercial cannabis activity, who needs to be licensed? All businesses that are conducting it. They need a separate license for each location where they're going to operate. So while somebody might have a chain of retail stores, they're going to need a separate license for each location. Commercial cannabis activity is cultivation, possession, manufacture, distribution, processing, storing, laboratory testing, packaging, labeling, transportation, delivery, or sale of cannabis and cannabis products. This does not include the personal use cultivation that was approved by the initiative. So right now, every household can have up to 6 plants. Local jurisdictions can set restrictions on those as far as like where they can grow them. So some local jurisdictions will require that the growing be done indoors or within certain structures. Some will allow it outdoors. So they do get control of that, but every household can have 6 plants. And then again, beginning January 1st, all commercial cannabis activity must be conducted between licensees. If you go to the next page, you'll see a notice.
Page 6?
Yes. So we posted this notice on January 9th, 2018. When the law went into effect and we started issuing licenses, there were a number of businesses, a very large number of businesses that were already engaged in commercial activities. These were the collectives and cooperatives that you've probably heard about. They are allowed to continue operating under that model without receiving a license from us, although they do have new restrictions, but that allowance will sunset on January 9th of 2019. So they got 1 year from the date we posted the notice that we were issuing licenses. They have until then to get licensed, otherwise they need to cease all commercial activity. If you go to slide 7, we have just a little overview of the licensing authorities. So the Bureau which is under the Department of Consumer Affairs, licenses testing labs, distributors. It says dispensaries on here because we can't get over that word. We say retailers now, and everybody still calls them dispensaries, but and micro businesses. And I'll go into more detail on each of these licenses.
One brief question. Is this true for both recreational and medicinal?
Yes.
Okay, thank you.
And so because it is one system, we issue people a license with an M or an A, which is medicinal or adult use, but they could also have both licenses and they can conduct both activities on one premises. And all of our regulations are the same. Cal Cannabis is under the Department of Food and Agriculture, and they license the cultivators. And then the Manufactured Cannabis Safety Branch is under the Department of Public Health, and they license the manufacturers. So if we go to slide 8, these are the list of license types we have. We have our distributors. We have a distributor transport only, retailers, not storefront retailers, micro businesses, testing laboratories. We have cannabis event organizers and temporary cannabis events. We have 2 types of licenses that we are issuing now. And slide 8, we have a temporary license, which is all we have issued so far. The temporary license required very few things, and the primary thing it required was approval from the local jurisdiction. The licenses are only good for 120 days, and these were really to allow those businesses that were already in operation to keep going while they gathered all the things that we require for an annual license, which is quite lengthy, including fingerprints, background checks, even premises inspections. Some of our security requirements, all these things were new, so they needed to keep operating while they acquired all these things and came up to speed. So we will extend their temporary license for 90-day periods.
Yep, she's answering you.
Okay.
So that gets it, you won't double it, but you'll extend it.
We will extend it, but the requirement is within that 120 days they submit a completed application for their annual, and that's really because it's going to take us a lot of time to review these, so they can continue operating. But then the annual license, which is valid for 1 year, and again with that one, we don't require approval from the local jurisdiction, but if the license would violate the local ordinances and stuff, we cannot issue it. So they're a little bit different. Again, and that's repeated on slide 10. Under HIMACURSA, locals can adopt and enforce local ordinances to regulate businesses, and which is including zoning, land use, license requirements, exposure to secondhand smoke, or they can completely ban it within their jurisdiction. At this point, we have quite a few jurisdictions in the state that have not done their ordinances yet, and they're working on them. So as the year progresses, we'll have more and more jurisdictions that will start offering licenses. So on slide 11, with this new plan, there is a track and trace system. So cannabis is tracked from seed to sale. Basically, every plant gets tagged with the unique identification number, tags, and it's tracked all the way through the process. Each licensee scans those in, so you will know when you have a final product at the end of the chain, when it's ready for customer purchase, we will know exactly what plant that came from. We're using Metric, which was awarded our contract. They are also doing it for Colorado, Oregon, Alaska, Maryland, and Michigan. Next slide, we have, so this is some of the requirements for licensure. One thing that's very important for us is all the owners have to receive a background check. So it's a little different than, we're a little different in licensing normal businesses where the business itself is licensed. This is more like licensing individual practitioners where you have to have fingerprint, background check. So to do that, we had to kind of get creative with the ownership piece. So you can see exactly how we've broken it down. And basically, we've required that at least one person that owns the business meets some qualification to receive that background check. And then aside from the ownership piece, we also require every person with a financial interest to be listed on the application. This is so we can ensure that there aren't hidden owners that are maybe that really are owning and controlling the business by ducking the background check somehow. It's also because anybody that holds a testing laboratory license cannot have an interest in any other business. And obviously that makes sense. You don't want lab results coming back because somebody also owns another business that they want their products to pass. So, and financial interest, basically we've made it pretty broad: investments into a business, loans, and any other equity interest. What isn't included as a financial interest, bank or financial institutions, if somebody were able to somehow get a loan from one of them, that would not be required. Diversified mutual funds, blind trusts, or similar interests where the people that are involved in those interests really don't have any control over the business or even really any control over where their money is being invested. So then if you go to the next slide, we start talking about our license types. Our distributors are very important. Distributors are the only licensees that can transport cannabis goods. They're also responsible for arranging for the laboratory testing. So when a cultivator is done with their product, if it's going to be dried flower, they will have it transported to a distributor, manufacture products, have those transported to the distributor. The distributor has a lab come to them and obtain the samples, and they hold on to all the products until the samples come back with a pass or fail. If they fail and they can be remediated, like if they're a manufactured product or a cultivated product that could then be somehow remediated into maybe a tincture or something and then be safe, they can do that. But if they can't be remediated, they're required to be destroyed by the distributor. Distributors also do quality assurance review, which is making sure that the products comply with all packaging and labeling before they get transported to retail. And they can also do general storage. We have a distributor transport only license, which allows them to transport goods between licensees but not to retail. And this is primarily for cultivators that want to transport their own products to a distributor or a manufacturer without having to pay for that. We do have an exception for the transport to retail, where we will allow immature live plants and seeds to be transported from a nursery to the retailer. And the reason those get to bypass the distributor and quality assurance is there's no testing that's done on those. In the Act, we also have the requirement to have a quality assurance monitor for the Bureau. This is somebody that would be either an employee or a contractor, and likely will end up being more than one person. And they will be doing random quality assurance reviews at the distributor's premises. So they will be making sure the testing is being done right, the sampling is being done right, they're arranged for that they're doing the proper quality control for packaging and labeling. And the other big important part is they will be making sure the distributors are collecting taxes appropriately. Because that is one thing the distributors also do, they collect all the taxes. So we will be inspecting those, and then also making sure that they're compliant with the track and trace system, so everything goes in there. Our testing laboratories, which is one of the most important pieces of this, must be accredited, and they must develop and implement chain of custody protocols to document the transportation, handling, and instruction of samples. They will be generating a certificate of analysis for each sample they analyze. And that certificate analysis goes back to the distributor and stays with the products. Any cannabis or cannabis products sold to or purchased by a customer must meet testing requirements. They will be testing for cannabinoids, foreign material, heavy metals, microbial impurities, mycotoxins, moisture content, and water activity, residual pesticides, residual solvents, processing chemicals, terpenoids, and homogeneity. I'm terrible at that word, but yeah. So we have quite a list of pesticides that they will test for that was developed by the Department of Pesticide Regulation for us, and we work closely with them on that. For retailers, we have two types of retailers. We have main retailer, which is a storefront that's open to the public, and they're also allowed to do deliveries of products. And then we also have a non-storefront retailer, and this is a retailer that's not open to the public and does sales entirely by deliver. They can have an A or an M license for the same premises. We restrict sales and deliveries from 6 a.m. to 10 p.m. Local jurisdictions can be more restrictive. Many are, but they cannot deliver anything after 10 p.m. or sell. All goods have to be placed in an opaque exit bag prior to leaving the premises. We require deliveries to be made by employees of the retailers, no Uber deliveries or any of that. Deliveries have to be to a physical address, and the retailer must be able to immediately locate all delivery vehicles, so we require them to have GPS, so you know where they're at. And we do restrict the amount of products they can carry at one time. Right now, it's a $3,000 limit of products. And obviously, they have to verify identification and age when they deliver. Our micro business license is kind of an all-encompassing license. It allows for cultivation that's less than 10,000 square feet, manufacturing of non-volatile extraction, so it can't be volatile extraction, infusion, and they can also do packaging and labeling. And then they can also do distribution and retail. We require that they engage in at least 3 of those activities to get this license. It's all on one premises, one license, so we require at least 3. They have to tell us which ones they're going to be doing and provide us quite a bit of information. For cultivation, we require the same things that the Department of Food and Ag will require of their cultivators, including a cultivation plan. And the same goes for manufacturing. We basically just refer to the regulations of public health and to supply all that information. And we work very closely with those 2 agencies too. And we also have a big one people have probably heard about, temporary cannabis events. We have issued our first license for an event, which took place in Sacramento 2 weeks ago. That was the first licensed event.
They're called a smoke on or something?
It was
There's a name for these things.
Yeah, it was a High Times Cannabis Cup.
High Times.
But quick question before I lose track of my question. For the temporary cannabis events, I've been to 1 or 2. How do you regulate what product enters the events?
The product will all have to be coming from the retailer. We do limit the amount they can have on hand, so very similar to what we allow in our retailers. They can only have a certain amount on display at one time. We limit it to what they would generally sell in one day. They can have more products in the back. Sort of the same with an event. They can only have what would be expected to be sold during that day of the event, and everything else has to be locked up.
Got it. Are they informing you? Let's say there's a recall. I don't know if there's a recall procedure yet, but somebody gets sick at one of the events. How do you trace it back?
There are recall procedures. Those are developed under the Department of Public Health because they do the manufacturing, and all manufacturers are required to have recall procedures.
Distributors get to package cannabis, so that's not a manufactured good.
Distributors can package dried flower, but they have to follow all the packaging and labeling requirements, and it also has to be tested too. So nothing would be going to an event that hasn't met all those requirements.
Shouldn't.
I mean, there are always possibilities for problems, but yes, the rules require that. And the rules require that the distributors transport the goods from the retailer premises to the event and like that.
So only licensed retailers can be part of these events?
Yeah, ideally. So it is a little bit of a confused area right now with people still operating without licenses under the collective cooperative model. But we have issued, like I said, we did our first temporary event, which we had local approval from Sacramento. We've all heard about San Bernardino, where we didn't have local approval, so we did not issue a license to them. These licenses do allow for on-site sale and consumption of cannabis goods, but they have to be held on the fairgrounds or district agriculture association. This doesn't mean it has to be held during the county fair, but it does have to be in the fairgrounds. So to get a temporary license, we first require the organizer of the event to be qualified and get their own license. They have to get a license, so background check and everything. Again, the sales have to be performed by retailers. Yeah.
Do these rules and regulations affect the sale to the veterinarian population?
there's no direct sales to like a veterinarian, they would be
Because
purchasing.
there are some animal use in these products.
Might be referring to CBD derived from industrial hemp, which we do not regulate.
You do not regulate.
Yeah, that does not fall under us.
Right now, veterinary they don't have authority for any kind of actual recommendation like certain doctors do. But
There, I believe there's talks of bills being pending on that, or if they have, I have to admit I lose track because there are endless bills on cannabis lately. So one thing, the access to the area where sales or consumption will occur is restricted to people that are 21 years of age or older, and consumption of alcohol or tobacco is not allowed. And on-site consumption must be done in accordance with the local jurisdiction's requirements. So whatever the local jurisdiction requires, we require to enforce. We require security to be present at these. And again, they must have written approval from the local jurisdiction to hold an event. On slide 20, we have the difference between our retail customers. We have adult use customers and medicinal customers. Adult use users must be at least 21 years of age and present valid ID. Our medicinal customers must be at least 18 years of age and present valid identification and a valid physician's recommendation. If somebody under 18 does have a physician's recommendation, they can have a primary caregiver or a parent obtain the medication.
How would they set the age guidelines? I mean, alcohol 21.
Yeah, 21 was in the initiative.
I thought it was 18.
18 is for medical use.
No, alcohol. My daughter told me it was 18.
Yeah, alcohol. It's 21.
Europe is 12, right?
Oh, you're right. No, I thought it was 16.
Okay, she turned 18. She told me it was
Are you going
To use cannabis and purchase it from our retailers, you have to be 21 or 18 with a physician's recommendation. You go to slide 21, we have some of the packaging and labeling requirements. All packages must be resealable, tamper evident, and child resistant. They cannot be made attractive to children, so no cute cartoon characters or anything. They have to contain certain government warnings. These are warnings similar to what you would see on alcohol, cigarettes, those types of things. A list of all the pharmacologically active ingredients, THC, CBD, other cannabinoids, and the THC and other cannabinoid amount has to be in milligrams per serving, servings per package, and then we need for THC the amount in milligrams for the package total. A warning if there's nuts or other known allergens in the package, and every package has to have the universal symbol, which is that triangle with a leaf and exclamation point. And they can also not include any health-related statement that is untrue in any particular manner, tends to create a misleading impression as to the effects on health of cannabis consumption. So you cannot have a product that says this will cure cancer.
What about if it says this will help you sleep better?
There are some allowances for stuff like that, but it has to be limited. You can't say something. On page 22, we have some limitations for cannabis products. These are the manufactured products. All edible products are limited to 10 milligrams of THC per serving and 100 milligrams of THC per package. Prior to this limit, there were products that had 1,000 milligrams or more of THC in them in a brownie. So now it's 10 milligrams per serving, no more than 100, and they have to have either the serving delineated on the product or like a card that's inserted in that shows what an exact serving is. And that is the same whether it's medical or adult use. For topical products and concentrates other products, adult use products are limited to 1,000 milligrams of THC per package. For medicinal products, those are limited to 2,000 milligrams of THC per package. So obviously, a medicinal would only be able to be purchased by a medicinal patient with the physician's recommendation and from a retailer that has an M license. There are some products that are prohibited. You cannot infuse alcoholic beverages with cannabis and sell those. Nicotine or caffeine additives. Although if caffeine is a naturally occurring element of a product like coffee or tea, that's allowed. Dairy products are prohibited. I believe public health allows some form of cannabis butter. I don't really understand the science of how that works, but that's the one exception. Seafood products are banned. Don't know why you want seafood in cannabis. And then products can't be in the shape of human beings, animals, insects, or fruits, and this is to prevent it from being attractive to children. So no edible gummy candies. You can have them in a square, but...
Was the dairy and seafood issue related to interactions or?
Yeah, they're products. So my understanding with the dairy and stuff primarily because they can't be shelf stable. Sometimes they require refrigeration, and that just creates a bunch of other issues. So, and I think the same with seafood. We do have enforcement. We have ongoing enforcement. We have sent out quite a few letters to people that are unlicensed. We have done many premises inspections. Right now, as we're inspecting the premises, obviously the goal is to help people come into compliance and be more education. But we are currently engaged in very active enforcement. For unlicensed activity, people that are engaged in that are subject to civil penalties of up to 3 times the amount of the licensee for each violation. Right now, our highest license fee is $120,000. So these penalties could be quite significant. The court can also order destruction of any products that are associated with this violation, and each day of operation constitutes a separate violation. So my math is a little fuzzy, but I think that's for our highest one, that's about $360,000 a day. And then criminal penalties will still apply to people that are engaged in unlicensed activity. For licensed activity, the Bureau has full access to inspect the premises. We can test vehicles, equipment, we can test cannabis goods, and we can copy records. The Department of Food and Agriculture and Public Health have also written into their regulations the ability for us to obtain samples if we get a testing discrepancy, so we can acquire products from them too. And we can issue citations containing orders of abatement, fines, license suspension, and license revocation. We also can use minor decoys, just like alcohol, so we can use them to go in and purchase.
Is there a limit per city? Like in San Diego, I think there are 9 registered.
Those are up to the local jurisdictions.
Okay,
at the state level, yeah, we haven't set any, but local jurisdictions are. A big part of this is the tax fund. We just had the first quarter, and I believe it was around $60 million. So the disbursements, as the tax funds come in, the first disbursement goes to pay off the general fund loan that all the licensing authorities have taken to set up our programs. After that, there's $10 million annually to look into impacts on public health costs associated with cannabis use, whether cannabis use is associated with an increase or decrease in use of alcohol or other drugs, impacts on treatment for maladaptive cannabis use and the effectiveness of different treatment programs, public safety issues, such as the effectiveness of packaging and labeling, advertising and marketing restrictions, which are aimed at preventing underage access primarily, and then studying the health-related effects among users of varying potency levels. Cannabis use rates, maladaptive use rates for adults and youth, and diagnosis rates of cannabis-related substance use disorders. Some additional disbursements after that, there will be $2 million annually to the University of San Diego Center for Medicinal Cannabis Research to further the objectives of the center, including the enhanced understanding of the efficacy and adverse effects of marijuana as a pharmacological agent. They are currently doing a study for us on the effects of driving, so to try and figure out how you determine whether somebody is under the influence of cannabis while they're driving, because right now there is no breathalyzer for it. There's disbursements to the State Department of Healthcare Services for programs that are designed to educate about and to prevent substance use disorders and to prevent harm from substance use. More disbursements for environmental restoration and protection. And then there's funds for state and local law enforcement. That's about it. The last slide has contact information for us. We have an email box where we get many emails daily. We respond to them quickly. The cannabis portal has links to all 3 agencies as well as a number of other agencies like the Secretary of State that have parts of this that play a role. That's generally where all the current information goes. It's great to follow along if you want to know what we're doing. And you can always subscribe to our listservs and send out any announcements. Anyone have questions?
Is there a taxation difference between medicinal use and adult use?
There is medicinal users that have the medical identification card get an exemption from property tax.
From issued by the county.
Yeah.
So there's physicians issuing recommendations, but if you actually register with the county, then you get 50%. You get an exception from the 50% excise tax. The problem there is that you have to pretty much classify yourself as a medical patient, and there's immigration issues and other things that might arise. So even if you're medical, you might not want to partake in registering yourself for a database.
Is medical pricing and recreational pricing the same or different?
They are the same.
Yeah, the question that I have is, how does the state protect the medical patients? So, for example, there's product that has to be labeled by the time it leaves the farm, either M or A. How do you know where it's actually going to end up?
It's because it's tracked down through with the track and trace system. So if it's labeled as medical, as of now, as it goes through the track and trace system, it can't deviate from that. We have allowed for the adult use market up until July 1st, we did a transitional period to allow them to do business and acquire product from the medical because there would be nowhere to acquire product.
So after July, that's going to stop. And then also, I'm under the impression that the Bureau is allowing for non-tested cannabis to enter the market as long as it's labeled non-tested. Is that correct?
That was part of the transitional period. Products that were on hand at that time, like on the day they were licensed, could be sold for a period of time. And we have our testing is phased in, so we had certain tests that were required for anything manufactured after the 1st of January or that was harvested after that date. They would have to comply with some of the testing, and then it phases in.
So there's potential product that could harm people that's not tested.
Yes, there are products that have not been tested.
What's the serving size based on?
The serving size, so in the Act that was created, the Act specified 10 milligrams per serving, and then the public health, their regulations limited it to 100 milligrams.
So usually serving size is related to calories, so in cannabis it's related
THC.
to THC and some scientific effect of that particular dose. Is that?
Yeah, I can't really speak to what public health thought, and they really are the experts on that.
Okay, so they're the ones that
set
in terms of the serving size.
Right. But I know they do have a Let's Talk Cannabis program now that its goal is to inform consumers about it, and they recommend people start with 5 milligrams because it can be it can be very potent, and it can come as a shock to people when they eat a brownie and 2 hours they feel great, and then 2 hours later they are very influenced by it.
Are you guys thinking about engaging the California Medical Board, the Osteopathic Board, in terms of like working with physicians if something does come up?
That's something I wouldn't know, but I'd be happy to go back and talk to the Bureau Chief and see if that's something she could coordinate.
Do you guys need anything from the Bureau? Or are you guys encountering patients talking to you guys about this?
It's kind of like drinking alcohol or having a glass of wine. It's very yeah. Yeah. So
So do those marijuana purified oils and things fall under your purview?
Like those would
All
be, the tinctures and those are all products that are sold in retail. All the rules governing how they're created and manufactured are under public health.
Yeah, there is some rumor that those cartridges are creating something called like popcorn lungs, where I don't know if the oil's not clean or something's happening where like your lungs are really getting affected with the technology now. But like cases like that, like how do you trace it back? That's what the Department of Public Health.
Yeah, and because they're all entered into track and trace, so we know what plant every product came from. So that's how you track it.
Claudia, some of your earlier questions sounds like this was assigned to health.
Yeah, exactly.
Because they were originally for lab, but now it sounds like they have a much bigger role since they assigned the actual dose.
Are there any regulations yet or discussion about state-to-state transfer of product or sale of product?
No,
or,
that's completely illegal at this point.
Is it still considered a federal crime?
Yes.
Yeah.
Up until January 4th, there was a guidance memo. That was called the whole memorandum, and it essentially said if you're going to have a regulated cannabis market, these are the things you need to do. And so we've complied with those requirements in it, but that was rescinded in January.
The last question.
So you said there's going to be some new amendments. Can you tell us if something that's coming online or some feedback that you guys heard that's really pressing that needs to really change?
Can't share that. Our readopt will be coming very soon. For readopt, everything has to be substantially the same. And then our final package, which probably will have some significant amendments. We have been getting lots of feedback, and our advisory board has been providing feedback. So we'll be incorporating theirs.
And speaking of Bureau has a number of people can actually call and report businesses that are not doing good business.
We do. We have a complaint that you can call, and I believe we do it online as well. And we are receiving complaints, and our enforcement, they're very active right now.
It's like oregano. Is that the end of your report?
That is.
Thank you for being here and for the report. Appreciate it.
Claudia, do you have your bill?
Oh yeah, that is a good time. I was waiting for.
Oh, I'm sorry.
That's it for the bill. AB
The 710, AB 710.
Does the Bureau have a stand on that? Can I ask?
No, I don't even remember which one it is at the moment.
Well, the only thing here that says is like if it's approved under federal law, right? It kind of raises some questions. So first of all, doctors don't know how to engage. Sounds like patients are getting engaged with physicians, but if the federal law lifts this ban, it says here that they're going to dispense a product. So how will you guys regulate?
Yeah, I can't speak to that.
You guys can speak to that. Sorry. So maybe that's where you make a decision. Do you want to dispense cannabis?
I don't.
So it just went to hearing on the 15th, and I'm just looking at what happened, and so the analysis. The purpose of the bill is to authorize healing art licensees to prescribe cannabidiol, the CBD products if one of specified changes in the federal law occurs, and to amend the Medical and Adult Use Cannabis Regulation and Safety Act to exclude federally approved products from regulation.
Is this an opportunity for us to change the Health and Business Code to add CMEs for cannabinoid education positions? Will a bill like this, like you remember we talked about like the board actually having a CME course?
Didn't I see a bill on that? That was somewhere.
Education.
Education on cannabinoid use.
Yeah.
Maybe some related. I'll have to check on that, but I thought that there was something somewhere in the works. But let me check on that.
But yes, this would be an opportunity when you have a bill out there to add a component to it.
Anything else? Okay. Thank you. Lunch is available up till 2 o'clock. So my question is, do we want to take a quick break, bring food back in here and continue? Does that work for everybody? Why don't we do that, because I think we'll feel much better.
I'm hungry.
I'm hungry too. So we use these VIP cards?
Yeah. I'm on a sugar.
And, okay, we're going to get back on, and what I have to do is verify your address.
Yes. My name is Megan Blair. I'm at 330 Parker Boulevard, floor 4, room 443, San Diego, California, 92101.
Are there any members of the public there with you?
There are no members of the public.
Thank you so much. I'd like to go to subject matter number 8, which is the board's president report. Being none, I'm going to pass. No, I'll be real brief. May 7th, I attended the Osteopathic Physicians and Surgeons of California board meeting in Sacramento. At that, I also participated with the legislative committee's bill reviews. And afterwards, we had a meeting with Assembly, what was the Assembly member's name? Wood? Was it Dr. Wood?
At our legislative reception,
Yeah.
we had Evan Lowe during the board meeting.
Oh yeah, Evan Lowe was at the board meeting.
And
And then there was a reception at the Osteopathic Physician Surgeons home office with Dr. Jim Wood, a dentist, who is the chair of which committee?
of the health committee.
Health Committee. And he told us that there is an infusion, a proposed infusion of $1 billion to healthcare, state of California. How much was for Psalm Brown? 200 or 300 million?
Something like that, I don't remember.
Okay, I don't remember the details. I forgot my notes. But it was a very good meeting. I was unable to attend the Federation of State Medical Board meeting in person because it was in Charlotte, North Carolina. The state of California has travel restrictions about going to there for any public business, but I was able to participate via webcast, and I was able to vote on resolutions that were important. The national legislative, licensing boards, and I was also able to vote on board members, and we have 2 DOs. One is from the state of Arizona, the other is from the state of Florida. We're board members now, so we are being represented well. Other than that, I don't have anything new and exciting to report, so I'd like to move to number 9, our executive director's report with Angie Burton.
Thank you, Dr. Shimoda. Okay, this report is to provide board members with updates on licensing stats, staffing issues, budgets, cures, and enforcement functions at the Osteopathic Medical Board, and no action is needed at this time. So the license stats, as of May 1st, 2018, the number of osteopathic physicians and surgeons holding a California license, there are 8,740 active licensees. Inactive license, 589, which totals 9,329. Additionally, there are still 1,025 licenses in a delinquent status, which means that it's still within the 5 years and we still have jurisdiction over these licenses. In-state licensees actively practicing in California, we have 7,539, and there are 53 doctors in California who are maintaining an inactive status. Number of license applications received from January 1st through April 30th, 273. Number of licenses issued in that same time period was 291. The number of days to approve a license application during January 1st through April 30th was 55 days. Applications with missing documents took an average of 152 days to complete and approve. Our 2 license renewal unit staff renewed 1,273 licenses between January 1st and April 30th. The renewal process also included all the reviews of CME documentation submitted for compliance before approving the renewals. Any questions on the licensing stats?
Thank you.
So the staffing, very briefly, the search for the medical consultant still continues. The deadline for the application has passed, and we are currently in the process of reviewing the applications received and hope to make a decision in the very near future. One of our enforcement analysts has informed us that she will be retiring at the end of this month. So we will start the search to fill that position that she's going to be vacating. Any questions on it? Staff? Okay, so budgets. The current fiscal year 2017-2018 expenditure projection and the Osteopathic Medical Board of California's contingent fund analysis is included in your board packet for your review. Are there any questions on those 2 documents? Now, the Department of Consumer Affairs has gone to that new fiscal budgeting system. So these are really projections, and they're getting caught up. So hopefully within the next month or so, we should get caught up on everything and have a much better idea. But this is as close as we can get at this point.
Question.
Yes.
After we're all caught up, then we'd be able to explore and find out whether they're going to give us our increased dollars for needed expenditures.
Yeah, that's the budget change proposal. I'll be speaking on that. But if you look at the budget report, in the actual fund condition, which is the black and white copy here, you'll see that there is that $1.5 million loan that was out to the governor is being put back in the fiscal year 1920's projection. And so that's that 1920 actually includes that 1.5 million reimbursement. So we did chat about, we're actually spending more money than we're getting in each year. So our reserve is going down. Right now, I do believe in 17-18, we're still at 12.6 months. Then it's going to go down to 10.3 in 18-19. And including the 1.5 million, it's only going to be at 12.6. So we were talking about when can we actually do a bill for a fee increase in order for us to provide the services that are required to protect consumers. I think that eventually we're going to have to do a fee increase. But at this point, the fund condition is too healthy, so we're not going to be talking about the fee increase at this time. Okay. So the space planning has been completed and the floor plan approved. We will be funding the majority of our redesign and remodeling costs for our current office space out of this year's budget. So we anticipate $75,000 from this fiscal year's budget and $25,000 from next fiscal year budget to spend on this renovation. And we've been approved to purchase an electronic filing system, which will be a tremendous space saver. And as the staff has submitted a major equipment purchase request for the next fiscal year, that amount is going to be included or added to next year's budget. So anytime we do a major purchase or a minor purchase request and it's approved, that amount is actually added to our budget, so it doesn't come out of our budget. The plan is to start the remodeling sometime after July of this year.
Can I ask, in Dr. Kirpin's position, the consultant, is that reflected under salaries and wages?
It was. No, it is included, and you'll see that there is a 19 on the overtime line. You'll see the current expenditure. It's like 1, 2, 3, fourth column from the left. The current expenditure, you'll see $19,334. That was his vacation payout. that we had to pay out, and that they put that under the overtime, but it really wasn't overtime. So an unfortunate situation, but there was some salary savings because we have not had a medical consultant salary for the last 2 to 3 months. Okay, and the staff will be submitting 2 budget change proposals this year. One for the additional staffing and funding to implement that postgraduate training license, which will become effective on January 1st of 2020. And the other increase is to our investigation budget and the expert reviewer budget. If these budget change proposals are approved, the effective date will be July 1st of 2019. Any questions on the budgets? So cures, the DOJ's certification of cures has occurred as of April the 2nd of 2018. The 6-month grace period is now triggered and the mandatory use becomes effective to October 2nd of 2018. So included in your packet is a flyer that we will be sending out to all our licensees via email and also posting it on our website. The medical board staff, the Medical Board of California staff, took the lead and created this brochure and has authorized all licensing boards with prescribers to utilize this brochure. So the question was earlier about the cures. So as of October 1st, all physicians who will be prescribing controlled substances for the first time to a new patient has to review the cures report. And if I do believe, I don't have the bill in front of me, but I do believe that if the patient has been prescribed the same drug renewed 4 times, then again you have to review it again before you prescribe it the 5th time. So we'll all include all that information, and it's going to be on the website.
Can I ask a question? It's a legal question. I don't know what this word means. Sorry. There is no private cause of action for a prescriber's failure to consult cures.
So it would be an administrative remedy by the government, or by the licensing entity.
A statute that would spell it out, right?
Okay.
No, that's
But
not
there
what
isn't
the
one,
question
right?
was. Sorry?
There isn't one.
We say no private cause of action, meaning that the board is the entity to take the action.
Okay. I'm sorry. Okay. I was thinking of just put that. Thanks.
And that is my report, and the enforcement report will be presented by Corey.
Dun, 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 the enforcer. Go ahead, Corey. Take us away.
Alright. Okay, so you guys all got copies of the report?
Yes.
Okay, so page 1. Some of this will be redundant. Most of it, I did add a new chart in there under investigations. We'll come to that. I'll explain it to you. Okay, the following OMBC enforcement report covers 12-month period starting from the second quarter of 2017 to first quarter 2018. The OMBC enforcement report is divided into 5 sections: intake, investigations, enforcement, performance measures, and probation. The data is reproduced from the BRI's enforcement reports. Also, I'm using a database called Qbert that kind of extracts data from our BRI system. All right, middle of the page in data table 1 above under total intake, that's the lower portion of that data table. OMBC received 531 complaints. 23 of these cases were convictions, arrests. During this period, 541 cases were assigned for investigations, and the average number of days to assign a case was 27. In figure 1.2 below, we see the intake totals for each month. In April 2017, there was a substantial increase in received complaints, while assigned complaints peaked at 73 in May, 56 in October, and 53 in March. There is a significant decrease in received and pending cases starting in February 2018.
That's good.
Well, I don't know if that's good because I think maybe, well, yeah, you can see our assigned cases went up, but the
Pendants went down.
yeah, the pending went down, received went down, and I
Things
don't.
are getting our work done, right?
Well, I don't know.
In office.
I don't know. So I think possibly one of the things that could come up is that there could be a bunch of cases sitting in our file that hasn't been put into the system yet. So we might have,
Like 40.
yeah.
No.
Okay. So that might be the situation. I don't know. That may be true. But I know we did. One of the changes we have made to our analysts is we want them to call more if necessary in terms of calling up the complainants to get more information. So that may sometimes reduce our ability to get these cases in quicker. So page 2. In figure 1.3 below, the bar graph illustrates the monthly average number of days to assign or close a complaint. The aging measures the period from the time the complaint was received in the office to the time the complaint is assigned to investigations. The performance target for intake is 30 days. The board met the performance target for the last 11 months with 2 exceptions. The month of October averaged 32 days, and January 33 days. The overall average for the last 12 months was 27 days. So moving on to investigations, desk or internal investigations. For all desk investigations during this period, data table 2 above breaks down the monthly totals for how many complaints were assigned and completed, monthly aging and cases pending. During this period, a total of 542 desk investigations were assigned, 508 were completed, and 152 cases were pending. The average number of days to complete a desk investigation was 86 days. The previous enforcement report, the aging was 90 days, so a bit of a decrease. Figure 2.2 below, the assigned and completed case load averaged 45 cases per month, except for May, in which assigned cases peaked at 73. And completed cases peaked at 59 in September. Pending cases averaged around 150.
Sorry to interrupt you. Can you increase your voice a little bit? You're too low. Your voice is too low.
Too low?
Outside voice.
Thank you.
I don't have a strong voice. So my take on this bottom graph is that we see that the pending cases are starting to average around 150, and in the previous years it was around 100, I believe. So we've seen an increase in the pending cases, and I don't know if that is because our caseloads are, we're getting more complaints, or what. I don't know why that is. Why the pendings are increasing.
Do we know there's a specific pattern to the pending in terms of what the concerns are? Are they a variety of concerns, or is there one concern more than others?
I think the pending cases in this particular area just designates that the analysts have a larger caseload. They're holding on to a larger caseload, and so I don't know why that is. If it's because we're getting more cases coming in now to the office.
So we don't know whether they're frivolous or significant at this point.
No, I think most of them are probably your basic complaints, not serious complaints. When they're at this level, they're not serious, but some of them could be, and we're just waiting for documents.
Okay. Thank you.
Okay, so page 4. Page 3. Okay. Field investigations. Data table 3 above breaks down the monthly totals for cases assigned to division investigations. Completed cases are either closed with insufficient evidence or referred to the Attorney General's office for disciplinary action. During this 12-month period, 23 cases were assigned to field investigations, 37 were completed, and 24 cases were pending at the end of March 2018. In figure 3.2 below, we see a substantial increase in completed cases during the fourth quarter of 2017 and the first quarter of 2018. So, I should have taken that out. That's not.
Which one?
And figure 3.2. That should have been taken out.
So
That was a different figure I had previously in there.
So 3.2 is not.
Yes, that's okay. You should cross that out because in the new 3.2 figures what I've done now is I'm looking at in field investigations, I'm looking at what type of investigations are out in the field. So I wanted you to see the breakdown of those, what type of allegations are there. So this is called, in our system they call it complexity, case complexity. So the case complexity is the breakdown of specific allegations that are under investigation. In figure 3.2, for all current open field investigations, there are 17, 52% excessive prescribing cases. 1 impairment case, 3 sexual misconduct cases, 1 hospital discipline case, 6 fraud cases, 2 negligent or injury cases, 1 unlicensed case, and 2 substance abuse cases. So these comprise of our more serious cases, and I wanted you to see the kind of the breakout of currently open cases of what those allegations are. As you can see, 50% of them are excessive prescribing cases.
On the negligent death injury, for those cases, did they come to you through litigation, or did they come to you some type of peer review that occurred?
It all starts with consumer complaints.
So I know that the consumer has a complaint, and then we have to the hospital records
Right.
or chart records to determine whether it was a death that occurred out of.
I think the 2 negligent cases, I think one is a complaint from a patient, and I think the other one may be either litigation or an 805. I'm not sure.
Okay.
But it was
You
designated.
get all the 805s, right?
Pardon me?
Well, there's an 805 file that comes in automatically.
It's not, well, the hospital has to report it to us.
Right. So the 805 has to come from the hospital directly to the court.
That is
Like
correct.
the medical.
Okay.
You have a medical.
Right, peer group, right.
But those 2 cases, I know one of them is just an average, not an average complaint, but from my patient. But the other one, I'm not sure if it was a hospital or if it was.
Okay, thank you.
Page 4, figure 3.3 below compares the aging of completed desk and field investigations per month. The aging is the average number of days to complete an investigation starting from the complaint received date to the date that the investigation is completed. The year-to-date average to complete a desk or internal investigation is a respectable 86 days. The year-to-date average for field investigation was 534, an increase from 478 from the last report. In September 2017, there was a single case that was closed with an aging of 985. That was a field investigation case that was closed at that high level of aging. So most of the field investigations, we're talking about maybe 2 cases or 3 cases closed that month versus a desk investigation we're closing 30 or 40 cases or 20, 25 cases. So the averaging is going to be a lot lower on the desk investigation investigations. And some of those field investigations were at one time in the desk investigation at the desk at one time. So it's got that completed. So those are going to be a lot higher in aging. So middle of the page, aging for desk and field investigations. So this aging matrix takes all of the cases together, lumps it all together, and so that's why your aging is not, it averages all the aging together. So the data table 4.
And can you tell the board again what our benchmark is for expectation for the aging?
Oh, for investigations?
Yeah.
But that will be on the second to the last page.
Okay.
You'll
Right,
see.
I'm just ahead of myself.
Yeah. That target is 360 days for investigations. And I think that's reasonable for desk investigations. I don't know if that's really reasonable for field investigations.
Right.
In data table 4 and figure 4.1, we see the aging matrix for the number of investigations that were closed per month within a specific time period. 288 cases were completed within 90 days. 144 cases were completed between 91 and 180 days. 54 cases were completed between 181 and 365 days. 20 cases were completed between 1 to 2 years. 9 cases were completed between 2 to 3 years. And 1 case was completed after 3 years. The majority of the investigations, or 84%, were completed within 6 months, and 94% were completed within a year. Page 5, enforcement actions. For all enforcement actions, State Table 5 above breaks down the monthly totals for each disciplinary action. During this 12-month period, 27 cases were transmitted to the Attorney General's office for disciplinary actions. 14 accusations and statement of issues were filed. 21 final disciplinary orders were filed. 4 cases were closed without disciplinary action. 4 citations issued, and 5 suspension orders were filed. At the end of fourth quarter 2017, well, actually, that should be first quarter 2018, there were 27 AG cases pending. Questions on that? Final disciplinary orders aging. Data table 6 on page 5. So on page 6 we have the commentary. In the data table 6 previous page, in figure 6.1, we see the AG matrix of the 21 final disciplinary orders that were completed during this 12-month period. The chart shows that the percentage of cases distributed within each aging period. Of the 21 final disciplinary orders, 2 cases were completed in 90 days, 1 case was completed within 180 days, 3 cases within 181 to 365 days, 4 cases within 1 to 2 years, 4 cases within 2 to 3 years, 3 cases within 3 to 4 years, and 4 cases over 4 years. Of the 21 disciplinary orders imposed, there were 5 probationary orders, 5 revocations, 3 surrenders, 7 reprimands, and 1 statement of issues denied. Just a side note, the system, the report that when I generated this, the final aging only gave me, I think, 18. So there was 3 cases that didn't show up in the system, and 2 of those were reprimands, and 1 of those was a revocation. And for some reason, I don't know why the report in Breeze didn't pick those up. So
that's a Breeze question to them.
Yeah, it's a Breeze question. Okay, moving on, page 7.
Can I ask you one quick question? Sure. The statement of issues denied.
That's when an individual is applying for a license, and we deny them the license based on they may have had a previous criminal conviction, and so they will appeal it, and then we issue a statement of issues. And the statement of issues is like an accusation, but they just call it a statement of issues. We have we're saying, hey, we have an issue with this guy, so then we go to a hearing, and then. Pardon me?
I understood what the other words were.
Okay. Page 7, performance measures. Some of this is redundant because like on the performance measure 2, cycle time intake, we can see that the target is 30 days, and then we can see the breakout per month, what we reached. So you can see, as I noted earlier, October and January 2018, we missed those target dates, but not by much. We missed them. PM cycle time 3, intake and investigation. Basically, the target date is 360 for all investigations that don't include any type of disciplinary action. We see we met that across the board. However, that doesn't take into account that, because those are all averaging. So if you just looked at the field investigations, it wouldn't meet that performance. Performance measure 4, that's for formal discipline. So we can see basically in September, October, November, we didn't meet those targets. And as you know, when we send those cases to the AG, we don't really have any control over it at that point in terms of how long it takes for those cases to be finalized. Oftentimes there's settlement issues going on. So sometimes there's still pending criminal actions on those cases that may take a while. Okay, page 8. Pending cases exceeding performance targets. These are all cases that are currently at the board being investigated either at the desk or in the field or at the AG. And these are cases that are exceeding the performance targets. Currently there are 18 desk investigations, 23 field investigation cases, and 16 attorney general cases. The highest aging value for a desk investigation is 990 days. For a field investigation, 1,053 days. And for an AG case, it's 1,537 days. Questions?
Who sets the target, and is it worthwhile? Like you were saying that you thought 360 days was very reasonable for desk investigations, but possibly not for field investigations. And looking at the formal discipline, I mean, it's most months it's over 540 with understandable reasons, but is it worthwhile to change the target or to look at changing that target, or
the target dates were set by DCA. It's the CPEI, which was the
Consumer Protection something initiative.
Is there something truly negative that occurs when we're over them, when there's clearly understandable, reasons and everything's in process, or is it just kind of accepted?
I think the target dates are just they're necessary there for us to move our cases so they don't become stagnant. We want these cases to get them closed as much as possible, but obviously there are cases that we don't have control over in terms of their time limit. But it's mainly so we can try and keep them going and not forget them, not to.
But the original motivation for setting those was because consumers felt like boards moved too slow. They felt like I complained, bad situation, and I gotta wait for years and years and years. And they're not thinking about the why, they're thinking about, and that's what drives those reset from consumer perspective.
Probation, currently 41 probation cases, of which 33 cases have a cost recovery totaling $339,120.34. As of May 11, 2018, $197,399.46 has been paid, leaving a balance of $141,721.38.
I think the field investigation numbers should start to improve because they have hired quite a few new investigators. They were really, there was a lot of vacancies in the investigations, and they just hired them. Of course, they're new, they're still going through the training and so forth, so it'll be a while before we see an improvement, but I think that we will see an improvement. And I think the reason why our numbers had gone up a little bit, the time frame, is because one of the analysts, her mother was very ill, so she had to take quite some time off from work. And then the other one had way too much annual leave balance. And Department of Consumer Affairs always says that if you have too much leave, you have to start making them take some time off. So unfortunately, very hard workers, so he had a ton of time left, so we had to force him to take every Friday off for about 3 months so that we could bring his leave balance down. So those were unfortunately our two enforcement analysts, and hence the reason why it was taking a little bit longer this time around.
So can we talk about our move back to HQIU?
Oh yes, and when we started losing the investigators, or it wasn't us, but when the HQIU, the Health Quality Investigation Unit, they started losing a lot of investigators. So we were asked for a time being to go to the Division of Investigations, which some of the Allied Health and other boards use. And we were told that they didn't have a lot of cases, and so that our case should move quickly at that unit. However, we found out that that wasn't the case. It was only just a couple of the field offices that really didn't have a full load. Most of the field offices had way too many cases, so it didn't really help for us to go there. But HQIU, again, as I stated, has hired a whole group of investigators, and so we're, as of July 1st, we're moving back to the health quality, and they're more familiar with the medical board and osteopathic board cases, so I think that the cases are going to be a lot smoother.
This will also help, I hopefully will help with the transition from these cases. Once the cases are done, we have to send them out to an expert reviewer, and that transition currently is a bit laborious because of the transition is difficult. The investigators on the Allied Health side have much more in contact with those expert reviewers, and hopefully the process will be much more smoother when we go back.
And we're soliciting for experts. We have a
Yes.
announcement on our website with the applications. We finally got an application for the very first time the other day, which I'll have to share with the board so you can approve or disapprove the application. But we're really in need of experts in various fields.
They compensate everybody.
Oh yes, they get paid $150 an hour for their review. And the only thing is that we ask that they complete it within 30 days, which is very difficult because they're all practicing physicians. So,
And providing good report.
and they have to be able to write a very strong report. And there is a format of the report on the website available, and there's also kind of a tutorial kind of, what is it called? The expert reviewer, guidelines. And, right, and yeah, and they do have training, and we've sent them to the training, but some of the reports we're getting from our DO experts are still very weak. So we really need somebody that can write strong reports, because if it does have to go to hearing and it gets admitted to court, in court for as an it has to be good. Weak ones just don't cut it. So we do still use quite a few of the MD experts, because for some reason their report writing is a lot better than what we're getting from our DOs.
If we can't find a deal, we have to find some way. The expert review, those reports, their testimony and opinion really sways the direction of that final disciplinary action and where that goes. So they're a very important part of the investigation. Very good.
Okay, thank you so much. Number 10, suggestions, future agenda items. We mentioned a couple things from the future agenda as we went through that we're going to follow up on. Does anyone have any additional items we need to put on the future agenda? Yes.
I don't have a future agenda item, but I do have a comment I want to bring up, and that is that there are several very important individuals in the room who either recently had a birthday or have one coming up. Dr. Zamudo, Dr. Lally, and Ange. I just want to say happy birthday.
Thank you.
It's actually Angie's birthday this year. We're swapping.
We're swapping. Yeah, there you go.
Thank you so much.
It turns.
I'm 29 again this year.
Actually, Angie said I can have an extra year here.
Yes, you can have my share.
Future date meetings.
So
On this Thursday, April 20th, there's a bunch of choices.
okay,
What was the
so
reason the 20th wasn't good?
I put down April 2019 because it was brought to my attention that the May meetings may be too late for opposition and support letters for legislative.
Right, yeah, because of the legislative session, sometimes I think it might be better if we had the meeting a little earlier so that we can put in our opposition or support letters.
Okay.
So maybe.
So
So
instead
move the May meeting to April.
yeah, so we had May 16th set, but if we can possibly move it to April instead.
That's fine.
So those are your choices of the Thursdays in April of 2019.
It's only a year away. Give me a sec.
Thursdays were always, better travel days, but I mean,
Maybe the 18th, because there's some, what do you think's going on into the month?
21st is Easter.
21st of April, 2019. Well, I'm the wrong month. It's the year.
Yeah, Friday the 19th is Good Friday.
The year.
So the 11th would be better.
So the year.
The 4th or the 11th. Or the 25th.
the 17th.
The week of Easter probably would be a good.
What was the date you threw out, Kathleen?
I just said the 21st was Easter. April 21st.
So that week I'm saying would not be good. But the
April 21st
But that's a
is
Sunday.
Sunday.
You're on the wrong year.
But
One year.
Was she 19?
No,
2019.
yeah, but she's talking about that week being Easter. No, Good Friday is the 19th.
Right, I'm just saying, you, as you're scheduling, you might want to consider the fact that people might take vacation
Oh,
either
I see.
before or after.
I see.
Or 11th.
Can we wait till September? Or do we need to do it now?
The May meeting?
We can wait until September. It was just we had already did the May 16th, and so.
I think we all ready to
Wednesday,
commit.
But
That's
that's
the question.
fine. We can.
Or we can look at the first week of May unless there's something going on the first week of May.
Well, what's better
Is
for
that
the
okay?
legislature, though? What's better for legislature?
Well, I think today, a lot of the bills have already gone through first hearing, so we kind of wanted to catch them before that. So, I don't know,
If you
Kathleen,
get a
you
second.
follow the calendar a lot closer than I do. May 2nd, would that,
It would help, but, probably end of March, beginning of April would be better.
better, right? Okay.
So I look forward to the 11th.
I could probably do the 4th of July, but if we can wait till September, I'll leave this at school schedule. So,
Can we put it out, let's wait till September then.
Okay.
So we will table the remaining 2019 meetings.
Yeah.
And then for September 27th, that's what we have scheduled for the
Yeah.
next meeting. We discussed San Diego.
Yeah.
Cheryl was able to give me a contact to the new courthouse down in San Diego. So I have sent an email. I'm just waiting for a response. If I don't receive one, I will give them a call. So yeah, and then we have January 17th of next year, which will be Sacramento because it's the first meeting of the year. So
I'm thinking too, the DA's office should have a
a conference room,
that we
right?
can use. I know Bonnie Jimenez is, she's running for office, but there's somebody in her spot right now, but we should be able to use,
The DA's office,
yeah.
which we may be for the day as well.
That's
what do we really require for realization?
Something that is able to accommodate the webcasting, so it needs to have high-speed internet, I would assume, and components for them to webcast because that is something that we have to.
an accessible web.
Yeah, no,
Right.
I gotta say, maybe we could, I have a couple of things, maybe we could get San Francisco and hospitals are in
yeah.
that would work for the next.
I want to talk to Megan for a second. Megan? Megan,
Yes,
is this your last meeting?
it is my last meeting.
I wanted to thank you for your years of service to our board and everything that you've done to help us. Wanted to wish you congratulations on your upcoming family developments, and we wish you all the joy and happiness, and would love to see you in the future when time allows you to come back.
Thank you. Well, I certainly enjoyed the education as a non-physician board member. And thank you so much for having me and answering my questions as I got up to speed, and thanks for allowing me to participate by phone call for the last couple meetings too.
Very good. So we're going to go ahead and adjourn the meeting. I'm going to hit the gavel, so I hope it's not too loud.
Okay. Good morning.
Okay.
Thank you.
Meeting adjourned.